The case they never expected to lose. She walked into that courtroom with no lawyer, no money, and no chance, or so they thought. What happened next left an entire legal team speechless. If you've ever been told you don't belong in a room, stay with me. This is the story of a mother who was handed an impossible case, a system designed to break her, and a 12-year-old boy who quietly changed everything. Watch until the end, drop a like, and comment the city you're watching from. I want to see how far this story travels. The elevator doors opened on the 14th floor of the Harmon County Courthouse, and Tiana Brooks stepped out into a hallway that smelled like floor wax, old paper, and the particular brand of dread that only government buildings seem to manufacture in bulk. She was wearing her best blazer, the navy one she'd bought 3 years ago for a job interview she didn't get, and she had her hair pinned back the way her mother had always told her looked serious. Her shoes were clean, her portfolio was organized, her hands were shaking. Behind her, rolling a small wheeled backpack that was almost comically oversized for his narrow shoulders, came Miles. 12 years old. Quiet in the way that some kids are quiet. Not because they have nothing to say, but because they are always listening. He wore a button-down shirt that Tiana had ironed the night before while he sat at the kitchen table with a highlighter and a legal pad, making notes in handwriting so small and precise it looked like it had been typeset. "You good, Mom?" he said as they walked. "I'm good," she said. She was not good. Courtroom 14C was at the end of the hall, past a row of dark wood benches where other people sat with their lawyers, papers spread between them, voices low and professional. Tiana noticed the way those lawyers moved, like the building belonged to them, like the air itself was their territory. She held her portfolio a little tighter and kept walking. When she pushed open the door to 14C, the first thing she registered was the table on the right side of the room. There were 4 of them. 4 attorneys from Hargrove Meridian Solutions, the company that had employed her for 6 years, the company that had fired her 8 months ago, the company that was now suing her for $140,000 and alleging fraud. They sat in a neat row behind a table stacked with binders, laptops, and the kind of organized authority that money buys. The one at the end, the lead attorney, a man named Philip Carver, was maybe 50, silver-haired, with the tan of someone who took long weekends and the expression of someone who had never once doubted that he would win. He looked at Tiana when she walked in. Then he looked at Miles. Then he looked back at Tiana with an expression that wasn't quite a smile, but wasn't not one either. Tiana walked to the plaintiff's table, her table, the one on the left, and set her portfolio down. Miles took the seat directly behind the partition, right at the front of the gallery, and unzipped his backpack with practiced quiet. Inside, 4 color-coded folders, 2 legal pads, a packet of Post-it flags in 3 colors, and a copy of the Federal Rules of Civil Procedure that he had checked out from the public library so many times that the librarian, Miss Okafor, had finally told him she was setting it aside specifically for him. The bailiff announced the judge. Everyone rose. The Honorable Sandra Whitmore was 61 years old, wore reading glasses on a chain around her neck, and had the energy of someone who had heard every possible excuse a human being could offer and was perpetually, quietly unimpressed by all of them. She settled into her chair, scanned the room with the efficient gaze of someone taking inventory, and opened the case file. "This is the matter of Hargrove Meridian Solutions versus Tiana Brooks," she said. "Case number 2024-CV-0881. We are here today for the preliminary scheduling conference." She looked up. "Counsel for the plaintiff?" Philip Carver stood. "Philip Carver, Your Honor. Carver, Rhodes & Associates, appearing on behalf of Hargrove Meridian Solutions. With me today are Associates Dana Lim, Marcus Webb, and Thomas O.C." Judge Whitmore nodded and looked at the other table. "Ms. Brooks, you are the defendant in this matter. Are you represented by counsel?" Tiana stood. The room was very quiet. "No, Your Honor," she said. "I am not. I am representing myself." The silence that followed lasted maybe 3 seconds. In the context of a courtroom, it felt considerably longer. Philip Carver made no visible expression, but Dana Lim, the associate sitting to his left, briefly looked down at her notes in a way that suggested she was suppressing something. Thomas Osei, the youngest of the 4, scratched his jaw. In the gallery, a man in a gray suit who appeared to be a paralegal exhaled through his nose with a sound that was not quite a laugh. Judge Whitmore's expression did not change at all. "You understand," she said, "that this is a civil matter involving complex financial allegations and that you will be held to the same procedural standards as represented counsel." "Yes, Your Honor, I understand." "You've reviewed the complaint?" "I have, Your Honor." "And you're prepared to proceed as a pro se litigant?" "I am." Judge Whitmore studied her for a moment. Whatever she saw or decided, she kept it behind her glasses and moved on. "Very well, Mr. Carver, you may proceed with the scheduling order." Carver stood again and began presenting the timeline his team had prepared. Depositions, discovery deadlines, motion filing windows, all of it laid out with the smooth, rehearsed confidence of someone who had done this 100 times. He spoke for nearly 8 minutes. When he was finished, he sat down and folded his hands and looked at Tiana with the patient expression of a man who expected to be waiting a long time. Tiana stood. She opened her portfolio to the first tabbed section, a section Miles had labeled in red ink scheduling/initial conference. "Your Honor," she said, "I would like to request a discovery period of 90 days rather than the 60 proposed by the plaintiff. I also request that the plaintiff provide a full privilege log with their initial disclosures, as the nature of the allegations involves internal communications that may be subject to claims of privilege, and I want to ensure those claims are made transparently." There was a pause. Carver's head turned slightly. The way a man's head turns when something unexpected happens in a room he believed he controlled. Judge Whitmore looked at Tiana over the rim of her glasses. "That's a reasonable request, Miss Brooks. Any objection, Mr. Carver?" Carver recovered quickly. "No objection to the discovery timeline, Your Honor. On the privilege log, we would argue—" "You'll produce a privilege log," Judge Whitmore said. "Ms. Brooks is entitled to know what you're withholding and why. That's not a request. It's procedure." She made a note. 90 days. Privilege log with initial disclosures. We'll reconvene for status in 45 days. Anything else?" "No, Your Honor," Carver said. "No, Your Honor," Tiana said. "Then we're adjourned." The gavel came down. People began to move. Carver leaned toward Dana Lim and said something in a voice too low to hear. Lim nodded and typed something into her laptop. Thomas Osei gathered his papers with the efficient calm of a young attorney who had learned to show nothing. In the gallery, Miles quietly put the cap back on his highlighter and added a small checkmark to the top of his legal pad. Beside it, he wrote, "Day 1. Privilege log secured. 90-day disk. Timeline secured. Proceed to Phase 2. He closed the pad and put it in the backpack. The story of how Tiana Brooks ended up in courtroom 14C without a lawyer, facing $140,000 in fraud allegations from one of the fastest-growing logistics companies in the Southeast, was not a complicated story. It was, in fact, the kind of story that happens to a specific kind of person with a specific kind of life. The kind where there is no cushion, no backup plan, and no room at all for anything to go wrong. Tiana had grown up in East Crestwood, which was the part of the city that people from other parts of the city drove around rather than through. Her mother had worked the night shift at a hospital laundry facility for 31 years. Her father had been present until she was 9 and then, gradually, wasn't. She had made it through high school, made it through 2 years of community college, and then made the pivot that a lot of young women in her situation made. She went to work. She got a job at Hargrove Meridian Solutions when she was 24, starting as a processing clerk in the logistics coordination department. She was good at it, precise, fast, reliable, in the way that people who know they cannot afford to be unreliable tend to be. Over 6 years, she moved up, clerk to coordinator to senior coordinator to what her title, toward the end, called a compliance liaison. She didn't fully understand what the title meant when they gave it to her, but she learned it fast. Her job was essentially to be the bridge between field operations and the documentation that was supposed to reflect what those operations were doing. Marcus had been her partner for 4 of those 6 years. Not married, but committed in all the ways that mattered. They shared an apartment, shared the bills, shared the particular exhausted pride of 2 people building something together in a city that wasn't making it easy. When Miles was born, Marcus was at the hospital for 16 hours straight and cried when the nurse put the baby in his arms, which Tiana had not expected from a man who claimed he didn't have a sentimental bone in his body. Marcus died in a car accident on a Tuesday morning 2 years ago. A truck ran a red light on the overpass. The police report said he would have died on impact, which Tiana had been told was supposed to be comforting. She had gone back to work 10 days later because she had to. 6 months after that, Hargrove Meridian Solutions had terminated her employment. The official reason listed on the separation paperwork was violation of company confidentiality protocols and misrepresentation of compliance records. She had never in 6 years received a negative performance review. She had never been written up. She had never, to her knowledge, misrepresented anything. The lawsuit arrived certified mail on a Thursday. $140,000 in damages plus attorney's fees, fraud, breach of fiduciary duty, a legal document that was 47 pages long and that referenced her by name 43 times. She had sat at her kitchen table with that document for 3 hours, reading it in the quiet that falls over an apartment at 10 o'clock at night when the kid is asleep. She read it twice. On the second read, she began to understand, dimly and with a growing sense of something she couldn't yet name, that whoever had written this document had been very careful about what it said and very specific about what it left out. She had called a lawyer that night, a number she found online under Civil Defense Attorney Free Consultation. The consultation lasted 12 minutes and ended with a number, a retainer of $8,000 minimum before they could do anything. She called 2 more firms. The numbers were similar. She called the county legal aid office. They told her they were at capacity and could put her on a waiting list. The waiting list, the woman on the phone said carefully, was currently running 5 to 7 months. The court date was in 6 weeks. She put the phone down on the kitchen table and sat there for a while in the silence of the apartment, thinking about Marcus and the truck and the red light on the overpass, and about Miles asleep in the next room, and about the $840 in her checking account, and about the fact that there was no one coming to help her. Then she got up and went to bed. She did not know at that point what Miles had already started doing. He had found the lawsuit 3 weeks earlier. Not because Tiana had shown it to him. She had kept it in her portfolio, which she kept in the high cabinet above the refrigerator, where she kept everything she didn't want him to worry about. But Miles had found it the way Miles found most things that she tried to keep from him, by paying attention. He had seen her face when the mail came. He had noticed the certified mail slip, then noticed its absence, then watched her spend 3 evenings with papers spread on the kitchen table, frowning at them with the particular frown she used for things that frightened her. He had waited until she was at work one afternoon and he was home from school, and he had found the portfolio in the cabinet, and he had sat at the kitchen table and read the entire 47-page complaint. It took him 2.5 hours. He used the dictionary on his phone 8 times. He made notes on a legal pad. By the time he finished, his face was very still in the way his face got when he was processing something that required all of him. Then he went to the library. He had always been a reader, the kind of kid who requested adult books from the children's librarian and then did his homework to rebuff the concerned looks he got when he checked them out. But this was different. Over the following 2 weeks, Miles checked out or read in the library 2 general guides to civil litigation, 1 state-specific guide to pro se representation, the federal rules of civil procedure, a practice guide to employment law, and 3 books on legal writing and document organization. He didn't tell his mother. Not yet. Instead, he started working on her documents. He had found, in the portfolio, not just the lawsuit, but a disorganized collection of Tiana's records from her time at Hargrove, pay stubs, performance reviews, email printouts, an employee handbook, some handwritten notes she had made during meetings. He made photocopies at the library for 37 cents a page, using money from the envelope he kept under his mattress from birthdays and odd jobs. He organized them into a system, chronological first, then by category. He made a master index. He flagged, with different colored tabs, things he thought were important. He was looking for the thing that didn't fit. The place where the story the lawsuit was telling diverged from what the documents actually showed. He hadn't found it yet. But he was looking with the focused patience of a 12-year-old who had learned from watching his mother work double shifts and still come home and help with homework that the way you beat something is by refusing to stop. It was on a Wednesday night, 3 weeks before the scheduling conference, that Tiana finally sat Miles down. She had been in the kitchen making dinner, spaghetti, which she made a lot because it was cheap and he ate it without complaint, when she turned from the stove and found him at the table with the portfolio open in front of him and 3 of his color-coded folders arranged around it and a legal pad covered in small, tight notes. She looked at him for a long moment. "How long?" she said. He looked up. 3 weeks. She set the wooden spoon down on the counter. She sat across from him at the table. She looked at the organized folders and the highlighted notes and the index he had made. "Miles, I know you're going to tell me not to worry about it," he said, "but I found some things, Mom. Things I think matter." She looked at him, really looked at him. His father's eyes, his father's way of going very still when he was serious. The button-down shirt he had put on, not because she asked, but because she now understood, he had understood this was a work evening. "Show me," she said. He opened the first folder. "The lawsuit says you committed fraud by misrepresenting compliance data in reports filed between January and September of last year," he said. "But look." He pushed a sheet across the table. It was a printout of one of her performance reviews, dated March of last year. "They gave you an outstanding rating in your compliance documentation in March. That's 4 months into the period they're saying you were falsifying things." Tiana looked at the paper. "They can't say you were committing fraud while simultaneously rating you outstanding for the exact same work," Miles said. "That's a contradiction, and it's in their own document." Tiana was quiet. "There's more," Miles said. "The complaint references Exhibit 12 6 times as evidence of the fraudulent reports. But I looked through all the papers, and there's no Exhibit 12 attached to the complaint. Either they forgot to include it, or they referenced evidence they don't have," Tiana said slowly. "Or they're hoping you won't notice," Miles said. She sat back in her chair. The spaghetti water was boiling. Neither of them moved. "Miles," she said finally. "I know," he said. "I'm 12. I can't be your lawyer. I know." He looked at her directly, the way he had been doing more and more in the past year, with that adult frankness that sometimes stopped her cold. "But I can help you not make mistakes. I can help you organize things so you can see them clearly, and I can find things. I'm good at finding things." She reached across the table and touched his hand. "You are," she said. "You really are." He nodded once, with a business-like resolution that was so much like his father that she had to look away for a second toward the window. "Okay," she said. "Then we work together. But you do your homework first every night, and you sleep. And if I think something is too much for you to carry, you'll tell me," he said. "I'll tell you," she agreed. "Deal?" He offered his hand with a formality that made her smile. She shook it. "Deal," he said. "Button." The weeks between that night and the scheduling conference were the hardest kind of hard. The kind that doesn't announce itself as extraordinary, but simply requires everything you have, every day, without rest. Tiana was working double shifts at the hospital, where she had taken a job as an administrative coordinator after Hargrove fired her, a position that paid $11 less per hour than what she had been making and required a 45-minute bus commute each way. She came home tired in the specific way that people who are fighting on multiple fronts become tired, not just physically, but in some deeper register, a fatigue that settled in the bones and made the distance between where she was and where she needed to be feel very large. But she came home and she sat at the kitchen table with Miles. Every night except the nights when she was on a closing shift, and sometimes on those nights too. They worked through the complaint line by line. Miles had developed over those weeks a methodology for analyzing legal documents that he had partly learned from the library books and partly invented himself, starting with the claims, then cross-referencing each claim against the evidence cited, then cross-referencing the cited evidence against the actual documents, then identifying the gaps. He kept a running list he called the questions the complaint doesn't answer, which by the third week had 23 items on it. He taught Tiana how to speak. This was harder than the document work. Tiana was sharp. She had always been sharp, had always been able to read a room and navigate it. But the language of the courtroom was a different language, one that operated by rules she hadn't been taught, and that valued a specific kind of controlled precision she had never needed in quite this way before. Miles had been reading not just the procedural guides, but transcripts of actual court hearings that were available on the state court's public access portal. "You can't say they're lying," he told her one evening, "even if they are." You have to say the evidence does not support their representation. It's the same thing, but the judge hears it differently. Well, why does it matter how the judge hears it if it's the same thing? Because the judge is deciding whether you're someone who knows how to work within the system, Miles said. If you sound like you understand the rules, you seem more credible. If you sound angry, I am angry. I know, but angry people sound like they might be wrong. Precise people sound like they know they're right. Tiana looked at her son for a moment. When did you get this old? She said. He almost smiled. I've been this old. She practiced. She practiced the way she had practiced for tests back in school, out loud, with Miles playing the judge or opposing counsel, holding her to the language, flagging when she slipped into the vernacular of her frustration rather than the controlled dialect of the argument. She got better, not at pretending to be something she wasn't, but at finding the version of herself that could inhabit this space and be heard. She also got angrier as she understood more, because the more she understood, the more she saw the shape of what Hargrove Meridian Solutions had done. Not just the firing, not just the lawsuit, but the deliberate architecture of it, the way the complaint was constructed to sound overwhelming, to use the weight of its own density to discourage response, to rely on the assumption that a woman with no lawyer and no money would simply not show up, or would show up and say the wrong things, and either way, the company would win. They had built something designed to work against someone exactly like her. She was going to take it apart. Know what you're asking for tomorrow? Know what you're asking for tomorrow, Miles said. 90 days and a privilege log, she said without looking up. Why the privilege log specifically? Because they're going to claim privilege on the internal communications about my termination. And if they claim it without a log, I can't challenge it. With a log, I can see what they're claiming is privileged and whether the claim is legitimate. There might be communications in there that don't actually qualify for privilege. Miles made a small sound of approval and wrote something on his pad. And if they argue against the 90 days? The complexity of the allegations justifies the extended timeline. It would be prejudicial to require a pro se defendant to respond to 100-page discovery requests in 60 days without adequate time to review and respond. Good. He tapped his pen against the pad. Mom. She looked up. You're ready, he said. I mean it. You know this stuff. She looked at her son, at this strange, serious, brilliant child who had spent 3 weeks in a library teaching himself civil procedure so he could help her, and she felt something move through her that she couldn't entirely name. It was love, and it was grief, and it was the particular fierce pride of a parent watching a child do something that leaves you breathless, and underneath all of it was the worry, always the worry, that she was asking too much of him, that she was letting the weight of her life press down on the small shoulders of a 12-year-old who was supposed to be playing video games and worrying about middle school. Go to sleep, she said. I'm not tired. Miles, he looked at her. She held his gaze. You've done enough, she said quietly. More than enough. I need you to go to sleep so you can think clearly tomorrow, because I need your eyes in that courtroom. A pause. Okay? He considered this, then nodded, with the measured formality of someone conceding a reasonable point. Okay, he said. He packed his backpack up, carefully, methodically, the way he did everything, and went to his room. Tiana sat at the table for another half hour, alone with the documents and the quiet apartment and the sound of a city going on outside the window. Then she closed the portfolio, put it by her bag, and went to wash the dishes. The morning of the scheduling conference, Tiana was up at 5:30. She made coffee and sat in the kitchen in the early dark and did not look at any documents. She had made a rule for herself. After 11 p.m. the night before, no more preparation. What she had, she had. Continuing to read and reread things she already knew was not preparation at that point. It was anxiety dressed as work. She thought instead about her mother, who had worked that laundry facility for 31 years and never once called in sick, who had looked at Tiana when Tiana was maybe 8 years old and had come home crying because a girl at school had told her she talked funny, and said, "Baby, the people who mock you are always afraid of something. Figure out what they're afraid of, and you'll know where your power is." She thought about Marcus and about the particular quality of his laugh, and about how he would have handled this, He would have handled it loudly, she thought. Big gestures. Some argument with the opposing counsel that would have had to be restrained by the bailiff. He had not been a person who went quiet under pressure. She loved that about him. She had also, now, in his absence, found something in herself that was different from his way. A stillness, a patience, a capacity to hold the long view that she hadn't known she had until she needed it. She thought about Miles, asleep in the next room. At 6:30, she heard him moving around. At 6:45, he appeared in the kitchen doorway, already dressed, the button-down shirt, the backpack, with his hair combed and his legal pad under his arm. "You made coffee?" he said. "You're 12. Can I have some?" "No." He sat down at the table and opened his legal pad to a fresh page and wrote the date at the top. "I looked up Judge Whitmore," he said. Tiana looked at him. "She's reversed 3 cases on appeal for counsel misconduct," he said. "She doesn't like when lawyers play games with procedure. If Carver's team tries anything cute with discovery, she's the right judge to have." He looked up. "That's good for us." Tiana wrapped both hands around her coffee mug. "Yeah," she said. "That's good for us." They rode the bus together in the early gray morning, Miles with his backpack and his legal pad and his calm, and Tiana with her navy blazer and her portfolio in her hands, which she folded in her lap and kept very still. Outside the window, the city went by. The street she knew, the neighborhood she had navigated her entire life, the particular landscape of a place that was always asking something of the people who lived in it. She watched it go by and thought about what her mother said about fear, and about what Miles had shown her about precision, and about the 47-page document that someone at Hargrove Meridian Solutions had paid a lot of money to construct. They thought they knew what she was. They had no idea what was coming. In courtroom 14C, after the gavel fell and the scheduling conference ended, and the opposing team gathered their binders and their laptops and their collective disbelief at being asked about a privilege log, by an unrepresented defendant, Philip Carver lingered for a moment in the aisle between the tables. He looked at Tiana as she organized her papers, unhurried, methodical, tabs in place. "Ms. Brooks," he said. His tone was professionally neutral in the way that some tones are professionally neutral while communicating something else entirely. "You might want to reconsider your position here. The evidence against you is substantial. The offer we put on the table—" "I'm aware of the offer, Mr. Carver," Tiana said, without looking up from her portfolio. "I'll review it and respond through the appropriate channel." A beat. "Of course," Carver said. He left. Behind the partition, Miles quietly placed a second checkmark next to his first one. Then he wrote, "They're watching her now." "Good. Let them watch." He put the cap back on his pen, zipped the backpack, and stood up. "Ready?" he said when Tiana reached him. She looked at her son, 12 years old, button-down shirt, backpack full of library books and legal strategy, and the particular genius that she had spent the past weeks learning to understand was not ordinary, had never been ordinary, would never be ordinary. "Yeah," she said, "let's go home." They walked out of courtroom 14C together, side by side, down the long hallway that smelled like floor wax and old paper, and the kind of dread that government buildings manufacture. They walked through it and out the other side into the morning. And in the backpack, rolling behind a 12-year-old boy who had spent 3 weeks in a library learning to fight a fight, his mother couldn't fight alone, there was a manila folder labeled in careful red ink, Phase 2, Discovery Review, Exhibit 12. Where is it? The question was already written. The answer was coming. The discovery package arrived on a Thursday. Tiana came home from the hospital at 6:40 in the evening, still wearing her ID badge, carrying 2 bags of groceries and the particular exhaustion of a woman who had been on her feet since 7 in the morning. She found it propped against the apartment door, a FedEx box, roughly the size of a small microwave, sealed with 3 strips of tape and addressed to her in the clean, impersonal font of a firm that billed $450 an hour. She set the groceries down. She looked at the box. Then she picked it up, unlocked the door, and carried it inside. Miles was at the kitchen table doing homework, algebra. She could see the grid paper. And he looked up when she came in, looked at the box, and set his pencil down. "Is that it?" he said. "That's it." He stood up. "Finish your homework first," she said. He sat back down. She put the groceries away, started water boiling for rice, washed her hands at the sink, and changed out of her work clothes into a sweatshirt and jeans. When she came back to the kitchen, Miles had finished the algebra page and was sitting with his hands folded on the table, waiting. She got a box cutter from the junk drawer and cut the tape. Inside were 312 pages of documents, organized into 11 binders, each tabbed and labeled in the manner of a firm that had a dedicated paralegal team and enough printer toner to last a decade. There was a cover letter from Philip Carver's office that was 4 pages long and explained, in language of exhausting precision, exactly what was being produced, what was being withheld, and under what privilege, and what the producing party expected from the receiving party going forward. At the bottom of the box, separate from the binders, was a handwritten sticky note on Carver Rhodes & Associates letterhead. It said, "Additional materials available per stipulated schedule. Questions re, privilege designations to be directed to Mr. Osei at the number above. No Exhibit 12. Miles noticed before she said anything. He had been flipping through the binders with systematic speed, checking the tab labels, running his finger down the index sheet that came with the cover letter. "It's not here," he said. "No," Tiana said. They indexed 12 exhibits in the complaint. They produced materials for 1 through 11, and then, he paused, ran the index again. "Exhibit 12 isn't listed in the privilege log either. It's not here and it's not claimed as privileged. It's just gone." Tiana poured herself a glass of water and sat down. "So either they made a mistake," she said, "or they referenced evidence that doesn't exist," Miles said, "or they do have it, and they're hoping we don't ask." "We're going to ask." "We need to ask in writing," Miles said. "So there's a record. A formal discovery deficiency letter." He pulled his legal pad toward him and uncapped his pen. "I looked up the format. You send it to opposing counsel identifying the specific deficiency and requesting cure within a reasonable time, usually 10 to 14 days. If they don't respond or they stonewall, you bring it to the court." Tiana looked at him across the table, at the algebra homework pushed to the side, at the legal pad already filling with notes, at the boy who was 12 years old and had just told her how to write a discovery deficiency letter. "Miles?" she said. He looked up. "After this?" she said carefully. "We're watching a movie. Whatever you want." He considered this offer with visible seriousness. "The one about the race car driver?" "Yes." "Okay," he said. "But let's draft the letter first." They drafted it together over the next hour, with the rice going on the stove and the city darkening outside the window. Miles read from his notes. Tiana typed on the laptop she had bought refurbished from a pawn shop 2 years ago, and that ran slow but ran. She had learned, as the weeks since the scheduling conference, to write in the voice the court would hear. Not the voice of her frustration, which was loud and entirely justified, but the voice of precision that Miles kept steering her back toward. The letter was 3 paragraphs. It identified the missing exhibit by name and reference number. It noted that the item did not appear in the privilege log, and was therefore not subject to a privilege claim. It requested production within 14 days and stated that failure to produce would result in a motion to compel. "One more thing," Miles said. "Add a line about the performance review." She looked at him. "The outstanding rating in March, right in the middle of the fraud period." He tapped his pad. "We don't want to tip our hand too early on the big arguments, but we should put them on notice that we've looked at their own documents carefully. It might make them nervous. Nervous people make mistakes. You want to put that in a discovery letter?" "Not directly, just..." He thought for a moment, which with Miles meant going very quiet for 3 seconds and then speaking with complete certainty. "Ask them to produce all employee performance evaluations from the relevant period, including supervisor sign-offs. That's normal discovery, but they'll know why you're asking." Tiana typed the additional request. She read the letter back once, slowly. Then she printed it, signed it, addressed the envelope, and put it by her keys to mail in the morning. Miles closed his legal pad. "Movie?" he said. "Movie," she said. But the 14 days passed the way most of the time passed in that apartment during those months, in a rhythm that had no give in it, where each component of the day required its full measure and there was nothing left over. Tiana worked. Miles went to school, came home, did homework, spent an hour at the library 3 days a week reading case law on the public access terminals while his friends were playing basketball in the park. She knew about the library hours because Ms. Okafor, the librarian, had called her at work one afternoon, not with concern, just to say that her son was using the resources well, and was there anything specific he needed. Civil procedure, Tiana had said, employment law, anything on fraud claims and burden of proof. There had been a brief pause on the other end of the line. I'll put together a shelf for him, Ms. Okafor said. The response to the discovery letter came on day 12, 2 days before the deadline, which Tiana understood was intentional, a demonstration that they would comply on their own schedule and not because of her timeline. It was a single page from Thomas Osei, the youngest of the 4 attorneys, and it said, in the clipped language of legal correspondence, that Exhibit 12 had been inadvertently omitted from the initial production and would be provided under separate cover. The phrase inadvertently omitted was doing a great deal of work. Under separate cover arrived 4 days later. Exhibit 12 was 11 pages. Tiana opened the envelope at the kitchen table and read it once through without stopping, and when she finished, she set it down and sat very still for a moment. Then she called Miles out of his room. He read it in 4 minutes, which she knew because she watched the clock. When he finished, he looked up at her with an expression she had not seen on him before. Not quite alarm, not quite excitement, something between the two. "Mom," he said, "I know. Do you see what this is? Tell me what you see." He laid the document flat on the table and put his finger on the header at the top of the first page. "This is a regulatory investigation report, a state agency report. It's dated—" His finger moved down. 19 months before you were hired into the compliance liaison role. Tiana nodded. "This report is about compliance violations at Hargrove Meridian," Miles continued, his voice taking on the rapid, focused quality it got when he was working through something. "Specifically about documentation irregularities in the logistics compliance records, the same records you were responsible for later." He looked up. "But you didn't do these. You weren't even in that role yet." "Right. So why is this Exhibit 12 in a fraud lawsuit against you?" The question hung in the air of the kitchen. Tiana leaned back in her chair. Outside, a car went by with music rattling its windows. Somewhere down the hall, a neighbor's television was audible through the wall. "Because," she said slowly, "they're trying to make it look like the problems in those records were a continuing pattern. And I'm the last person who held the role, so they're going to argue that I was part of that pattern." Miles stared at the document. "But the violations in here predate you by almost 2 years. You can prove you weren't even doing that job when this happened." "Yes." "So they're using an old regulatory problem to make a new lawsuit against someone who wasn't there." "That's what it looks like." Miles was quiet for a moment. Then he said with a careful steadiness that reminded her so much of Marcus it physically hurt, "They thought you wouldn't find this. They thought if they buried it in the production on day 16 when the deadline was day 14, you'd be overwhelmed and you wouldn't read it carefully." "Probably," Tiana said. "They don't know you," he said. She looked at her son. "They really don't know you," he said again, and there was something in his voice, not arrogance, something quieter and more durable than that. Pride. The particular pride of someone who has watched a person work and understood exactly what they are capable of. Tiana picked up Exhibit 12. "We need a timeline," she said, "documented. Every date in this report cross-referenced against my start date in that role. Every compliance action they list with the corresponding date. We need to show that the history they're trying to pin on me was already written before I got there." Miles was already reaching for his legal pad. "I'll start tonight," he said. "After dinner." "After dinner," he agreed. The next status conference was 3 weeks away, and the days between were packed with the particular density of a case that was, whether or not any court had yet acknowledged it, starting to shift. Tiana filed her initial document requests and interrogatories. Miles had helped her draft them over 2 evenings, pulling from templates in one of his library books and adapting the language to the specifics of her case. She requested all internal communications regarding her termination, all documents related to the state regulatory investigation, all performance evaluations, not just hers, for anyone in the compliance liaison role going back 4 years, all communications between Hargrove's legal department and the state regulatory agency. The interrogatories asked, among other things, when did Hargrove become aware of the pre-existing regulatory investigation? Who at the company had knowledge of that investigation at the time of Tiana's hire? Who authorized the decision to include the pre-existing investigation report as an exhibit in a fraud lawsuit against an employee who had not been in the role at the time of the investigation? Carver's office responded to the interrogatories with a set of objections that ran to 14 pages. Every question, it seemed, was objectionable on one ground or another. Overly broad, unduly burdensome, protected by attorney-client privilege, protected by work product doctrine, not reasonably calculated to lead to discoverable evidence. Miles read the objections on the evening they arrived, sitting at the kitchen table with a red pen, making small annotations in the margins. They're objecting to everything, Tiana said. They're objecting to everything, Miles agreed, but they can't. He underlined something. Look, they're claiming work product protection on communications between the compliance department and the legal department, but work product only protects documents prepared in anticipation of litigation. If those communications happened before anyone knew there was going to be litigation, they're not protected, Tiana said. Right. And the question of when they anticipated litigation is actually really important here, because if they were planning to sue you before they fired you, he paused, thinking, then the communications about the termination might not be privileged either, Tiana said, because they were already in anticipation of litigation. Miles tapped his pen twice on the pad. That's a motion to compel argument, and it's a good one. He looked at her. You need to file a motion to compel on at least 3 of these interrogatories. I've never filed a motion to compel. I found the format, he said, and slid a photocopied page across the table. The library had a practice guide. She looked at the page. She looked at her son. Of course it did, she said. Well, the motion to compel took 5 evenings to draft. It was 9 pages long, cited 6 procedural rules, and argued, with the kind of structured clarity that Tiana was getting better at by the week, that Hargrove's objections were boilerplate, unsupported, and designed to obstruct rather than engage. She was proud of it, not because it was eloquent. She had learned that courts didn't particularly want eloquence. They wanted logic and procedure, but because it was right. Every argument in it was correct. She knew it was correct because she had built it piece by piece, from the documents, from Miles's research, from the hours at the kitchen table that had slowly, week by week, transformed her from a woman reading a 47-page complaint in terrified incomprehension to a woman who could look at a 14-page objection filing and identify precisely which objections would hold up and which ones wouldn't. She filed it through the court's electronic system at 11:15 p.m. on a Tuesday. Miles asleep in his room, the apartment quiet around her. Then she sat for a moment in the kitchen with her hands around a cold mug of tea, and she thought about the woman she had been 8 months ago, sitting at this same table with the certified mail, the 47 pages, the $840 in her checking account. That woman had been so frightened that the fear had a physical quality, a pressure in the chest, a difficulty drawing full breath. She was still frightened. She would be lying to herself if she said otherwise. But the fear had changed texture. It was no longer the fear of helplessness. It was the fear of a person who is moving through something difficult and knows that movement is the only option. She washed her mug, turned off the kitchen light, and went to bed. The response to the motion to compel came from Philip Carver himself, not Thomas Osei. 8 pages, and the tone of it was different from what had come before, less smooth, more pointed. He argued that Tiana's requests were a fishing expedition, that she was seeking documents irrelevant to her defense, and instead attempting to conduct an investigation into the company's internal operations, that the court should deny the motion in its entirety and consider an award of fees for the burden imposed by the filing. He's annoyed, Miles said when she read it to him. Yeah. Good. He thought for a moment. He's calling it a fishing expedition because he doesn't want to say what the documents actually are. If the documents were harmless, he'd just produce them and argue you wasted his time. He paused. He's protecting something. What do you think it is? Miles was quiet for a long time, longer than usual. I think, he said finally, that there's something in those internal communications about the regulatory investigation that they don't want you to see. Something that shows they knew about it before they hired you into that role. And maybe that they put you in that role specifically because they needed someone to be responsible for those records going forward. He looked up. Someone who could be the face of it if it ever became a problem again. The kitchen was very quiet. Miles, I might be wrong, he said. I don't have the documents. I'm just reading the shape of what they're refusing to show. Tiana sat back and looked at the ceiling for a moment. You're not wrong, she said, because she had been thinking the same thing. Had been circling it for 2 weeks, approaching it from different angles, not wanting to say it out loud because saying it out loud meant the thing she was starting to understand was real. She had been hired into that role. She had been given the title, the access, the responsibility. And 18 months after she started, when the company's old problems began to resurface in a new regulatory inquiry, they had fired her and sued her, and the lawsuit had included, buried in the production, a report about violations that predated her by 2 years. She hadn't been their employee. She had been their contingency plan. Okay, she said. She stood up, went to the counter, refilled her water glass. She stood at the kitchen window looking out at the city for a moment. If that's what this is, she said, then the internal communications aren't just relevant to my defense. They're the entire defense. She turned. And we need them. We need the judge to agree, Miles said. The status conference is in 9 days. She came back to the table. We go in there with the motion to compel, we push on the Exhibit 12 timeline, and we make sure Judge Whitmore understands that the discovery obstruction is not incidental. It's systematic. Miles nodded slowly. There's one more thing, he said. He reached into his backpack and withdrew a folder. The blue one, which was labeled Regulatory History. He opened it on the table. I went back through the state regulatory agency's public records database at the library, he said. They have a public docket, investigations that have been opened and closed. You can search by company name. He spread 3 printed pages on the table. Hargrove Meridian Solutions had a compliance investigation opened 26 months ago. That's 3 months before you moved into the liaison role. The investigation was closed, marked resolved by consent agreement, 14 months ago. That's 8 months before they fired you. Tiana stared at the printouts. They were under investigation when they put me in the role, she said. Yes. And the investigation ended while you were the liaison, while you were the one signing off on the compliance documentation. The silence in the kitchen was very complete. They used me to close it, Tiana said. It wasn't a question. Her voice was level, but something behind her eyes was working through something that was beyond anger, into a region where anger becomes something harder and colder and much more dangerous in a courtroom. That's what I think the documents would show, Miles said carefully. If we could get them. We're going to get them. She gathered the printed pages, added them to the blue folder, closed it. At the status conference, we're going to show Judge Whitmore the public docket record, cross-reference it against the Exhibit 12 report, and argue that the internal communications we requested go directly to the central question of who knew what and when. She looked at Miles. Can you have the timeline ready, documented, sourced? Yes, he said. By Friday? By Wednesday, he said. He had it by Tuesday evening. It was 6 pages, handwritten first and then typed by Tiana on the laptop. And it was the kind of document that, once you read it, reorganized everything else you thought you knew about the case. It started 26 months ago, with the regulatory investigation opening. It moved through the timeline in careful dated entries, the investigation, her promotion into the liaison role, the specific compliance report she had filed and when, the consent agreement, the investigation's closure, the new regulatory inquiry that had apparently opened 9 months ago and that Tiana only knew about because Miles had found a brief reference to it in a trade newsletter he had found at the library. The new inquiry. Miles had flagged it with a yellow tab and written next to it, in careful letters. This is why they fired her. The second investigation opened. They needed a scapegoat for what's coming. That note was not going in the court filing, but the public record of the first investigation's timeline was. Miles, Tiana said, reading through the timeline for the 3rd time. Yeah. This is... She stopped. I know, he said quietly. If this is right, it's right. Every date in there comes from a public record source. I footnoted them. He looked at her with the direct steadiness that was so characteristic of him. This isn't my speculation, Mom. This is their own timeline. I just put it in order. She set the document down carefully on the table. She was quiet for a moment, processing the way she had learned to process, methodically, without letting the enormity of it collapse into emotion before she had figured out what to do with it. Then she said, "The status conference. We put this in front of Judge Whitmore." "With the motion to compel pending," Miles said, "so she can see why the internal communications matter." "Yes." He reached across the table and adjusted the yellow tab on the timeline so it was perfectly aligned. "They built this whole case on the assumption that you'd be too exhausted and too scared to read carefully," he said. "They thought they were fighting someone who didn't have the resources to fight back." "They thought right," Tiana said. "About the resources." She picked up the timeline. "They thought wrong about the rest." From across the table, her 12-year-old son looked at her with the quiet pride of someone who had never, not for one moment, doubted which way this was going to go. Outside the window, the city made its ordinary nighttime sounds, traffic and voices and the distant wail of something somewhere. And inside the apartment, a mother and her son sat at a kitchen table surrounded by 6 pages of documented dates and the particular stillness of people who have found the thing they were looking for and are deciding now exactly what to do with it. The status conference was scheduled for 9 in the morning, and Tiana was in the courthouse lobby at 7:45. She had learned, in the weeks since the first conference, that arriving early was not just practical, it was psychological. The courthouse had a particular atmosphere in the early morning, before the day's full machinery engaged, when the hallways were still quiet and the light through the high windows was gray and flat and honest. In those minutes, she could walk the building like it belonged to everyone, which it technically did, and remind herself that the marble and the wood and the elevated bench were not inherently hostile. They were just a room where arguments were made, and she had an argument. She sat on a bench near the window on the 14th floor and went through her materials one final time. The motion to compel, tabbed. The 6-page timeline, 3 copies. The public regulatory docket printout, sourced and footnoted in Miles's careful hand. A 1-page summary of the Exhibit 12 discrepancy, which she had drafted herself and which stated the problem plainly. The exhibit referenced in 6 places in the plaintiff's complaint predated the defendant's tenure in the relevant role by 19 months and had been omitted from initial production without privilege designation. She read it the way she had learned to read her own work, as a stranger would, looking for the places where the logic required a leap she hadn't yet justified, or where the language became emotional in a way the court wouldn't receive. She found 2 places and fixed them in pencil before Miles arrived at 8:15, slightly out of breath, his backpack over both shoulders and his legal pad already open. "Bus was late," he said. "I know. Sit." He sat beside her on the bench. He looked at the papers in her hand. "How does it read?" he said. "Clean," she said. "I made 2 adjustments." She showed him. He read, nodded once, made a note on his pad. "Carver will argue that the regulatory docket is irrelevant," he said, "that it's a public record from a proceeding that was closed by consent and has no bearing on your individual conduct." "I know." "What do you say?" "I say the relevance isn't the proceeding itself. It's the timeline. The question isn't whether the consent agreement resolved the regulatory issue. The question is whether Hargrove knew about an active investigation when they placed me in the compliance liaison role, and whether the internal communications they're refusing to produce would shed light on what they knew and when they knew it." She said it without looking up from the pages. Level, precise, the cadence she had been practicing for weeks. Miles was quiet for a moment. "Say it exactly like that," he said, word for word. Carver arrived at 8:50 with Dana Lim and Thomas Ossie. Marcus Webb, the 4th attorney, was absent today, replaced by a woman Tiana hadn't seen before, 50-ish, with the bearing of someone senior brought in for a specific purpose. Carver introduced her to the courtroom clerk as Patricia Hollins from the firm's appellate division. Appellate division. Tiana noted this, kept her face still, and filed it in the part of her mind that Miles had helped her develop over these months, the part that collected what the other side's choices revealed about what they were worried about. They were worried enough to bring appellate counsel to a status conference. Judge Whitmore entered at 9:02. She surveyed the room with her customary inventory expression, settled into her chair, and opened the file. We're here on a status conference in Hargrove Meridian versus Brooks, with a pending motion to compel filed by the defendant. She looked at Tiana over her glasses. Ms. Brooks, you filed the motion. You go first. Tiana stood. She spoke for 11 minutes. She laid out the motion in the order she and Miles had structured it. The original requests, the objections, the specific grounds on which each objection was insufficient under the rules. She presented the Exhibit 12 discrepancy. Exhibit referenced throughout the complaint, not in initial production, not on the privilege log, belatedly produced after a formal deficiency letter dated 19 months before the defendant's tenure in the relevant role. She presented the timeline, placed 3 copies on the bench, handed one to Carver, kept one, and walked the court through the dates without editorializing, letting the sequence speak for itself. She cited the public regulatory docket record. She made the relevance argument precisely as she had rehearsed it on the bench outside. When she finished, she said, Your Honor, the defendant respectfully submits that the plaintiff's discovery objections are not legitimate legal positions. They are a strategy. The documents being withheld go to the core question of this case, which is not whether compliance records were inaccurate, but who knew about pre-existing compliance problems and when, and whether the defendant was placed into a role specifically because those problems existed and someone needed to be accountable for them going forward. She sat down. In the gallery, Miles wrote on his legal pad, Good. Judge Whitmore had not looked away from Tiana during the argument. Now she looked at the timeline for a long moment, then looked at Carver. Mr. Carver. Carver stood. He was smooth, she would give him that. The smoothness of decades of practice, of a man who had argued in front of judges his entire career and knew how to read a room. He acknowledged the Exhibit 12 issue with a calibrated concession. Inadvertent omission, now cured, no prejudice to the defendant. He characterized the regulatory docket as an irrelevant closed proceeding. He argued that the internal communications were legitimately protected by attorney-client privilege and work product doctrine because they had been prepared in anticipation of exactly this kind of litigation, and that Ms. Brooks's request amounted to demanding a roadmap to the plaintiff's legal strategy. He was good, he was organized and precise and comfortable in this room in a way Tiana was still working toward. But, Mr. Carver, Judge Whitmore said when he had finished, you've claimed work product protection on communications between your client's compliance department and legal department. When did Hargrove Meridian first anticipate litigation against Ms. Brooks? A pause. Small, controlled, but there. The company developed concerns about Ms. Brooks's conduct during the period in question, Your Honor. Legal was consulted as those concerns developed. When, Judge Whitmore said again, did the company first consult legal counsel regarding Ms. Brooks specifically? Another pause. Longer. I would need to verify the specific date, Your Honor. You would need to verify it. Judge Whitmore's voice was even. You're the lead attorney in this matter, and you don't know when your client first consulted legal regarding the defendant? Carver made a small adjustment in his posture, almost imperceptible, but Tiana caught it. I can represent that it was within the period covered by our privilege designations, Your Honor. That's not an answer to my question. Judge Whitmore wrote something in the file. Ms. Brooks raises a legitimate point about the privilege designations. If legal was consulted about Ms. Brooks before a decision was made to terminate her employment, the question of whether those communications are work product or ordinary business communications becomes much more significant. She looked at Carver steadily. I'm going to need you to produce a detailed privilege log, not the summary you submitted, a detailed one, that includes the dates of each communication, the participants, and the specific basis for the privilege claim. You have 21 days. Your Honor, that request is not a request, Mr. Carver. That's an order. She looked back at the file. On the question of the interrogatory objections, I've reviewed them. Several of your objections lack sufficient specificity to be evaluated. I'm ordering supplemental responses on interrogatories 3, 7, and 9 within 14 days. She looked at Tiana. Ms. Brooks, I want to be clear. The court is not prejudging the merits of this case. What I am saying is that you are entitled to the same discovery any represented defendant would receive, and the production and objections I've reviewed this morning do not meet that standard. She looked back at Carver. I trust we won't be here again on the same issues. No, Your Honor, Carver said. No, Your Honor, Tiana said. The gavel came down. In the hallway afterward, Carver caught up with Tiana near the elevator, without his team, which she noticed. Ms. Brooks. He fell into step beside her in a way that was too casual to be casual. You've done impressive work, I mean that. She kept walking. Thank you, Mr. Carver. I want to revisit the settlement offer. The company is prepared to cease. Mr. Carver. She stopped and turned to face him. She kept her voice even and her posture still. I appreciate the conversation. Any settlement communication should be in writing and directed to me through the court's filing system, so there's a record. You know that. He looked at her for a moment, a beat longer than a professional interaction required. Of course, he said. She turned and walked to where Miles was waiting by the elevator, his backpack on and his legal pad closed. What did he say? Miles said. He wants to revisit the settlement offer. Miles pressed the elevator button. Because Judge Whitmore scared him. Because Judge Whitmore scared him, Tiana agreed. The elevator opened. They got in. As the doors closed, Tiana caught a last glimpse of Carver standing in the hallway, watching them, with the expression of a man recalibrating something he thought he had already calculated correctly. The doors closed. Good, Miles said. The detailed privilege log arrived on day 19, 2 days before the deadline. It was 41 pages. Tiana received it on a Saturday morning, and by Saturday afternoon, she and Miles were at the kitchen table with it spread between them, Miles with his red pen, and Tiana with the original interrogatory responses and the timeline document they had built. The log listed 117 communications being withheld under privilege claims. Each entry had a date, a list of participants, and a one-line description of the subject matter, as vague as the rules allowed, but enough to work with. Miles found it on page 12. Mom. She was cross-referencing something at the other end of the table. She looked up. He slid the log toward her, his finger on an entry. It was dated 31 months ago, 4 months before the regulatory investigation had opened, per the public docket. The entry listed 3 participants, someone identified as GC, General Counsel, and 2 executives from the Compliance and Operations divisions. The subject line read, Legacy Compliance Documentation, Strategic Considerations. 31 months ago, 5 months before the investigation opened, 7 months before Tiana was promoted into the compliance liaison role. They knew, Tiana said. They were discussing it before the investigation even opened, Miles said. His voice was quiet. They knew there was a problem with the legacy documentation. And then 5 months later, there's a state investigation into exactly that problem. And then 7 months after that, they put me in the role. Miles looked at the entry again. He underlined it carefully with his red pen. Then he flipped forward in the log, scanning. 12 pages later, another entry. This one dated 23 months ago, 2 months after the investigation opened. 5 participants, including now a name identified as outside counsel. Subject line, Brooks appointment, compliance transition strategy. They both stared at it. Brooks appointment, Tiana said. Her voice came out very steady, and she was aware of choosing, consciously, to keep it that way. They were talking to outside counsel about your appointment to the role 2 months after the investigation opened, Miles said. They were discussing the compliance transition strategy with lawyers while they were under investigation. Yes. She sat back. She put her hands flat on the table, a grounding gesture she had developed, she realized, sometime in the last several months, a way of making sure she was still physically in the room when her mind was working through something that wanted to pull her somewhere else. They can claim those are privileged communications, she said. Yes, but they have to claim the specific privilege basis, and work product doesn't apply if the communications were made in the furtherance of a fraudulent scheme. Miles said this carefully, the way he said things he had read rather than things he had worked out from first principles, with the faint precision of someone quoting without quoting. There's an exception, the crime-fraud exception. If a communication was made in furtherance of fraud, it loses privilege protection. Where did you read that? Practice Guide at the Library, Chapter 9. He looked at her. I know you can't use that phrase in court without knowing what you're doing. I know it's a high bar. He paused. But I think you need to know it exists. Tiana looked at her son. 12 years old, red pen, 41-page privilege log, 12 pages in, already flagged in 2 places. Yeah, she said softly. I need to know it exists. Aunt. 3 days before the key hearing on the motion to compel, Carver filed an emergency motion to dismiss. It arrived in Tiana's email from the court's electronic filing system at 6:17 in the morning when she was still in the kitchen making coffee. She opened it on her phone, read the first paragraph, set the phone down, picked it up again, and read the full 22 pages standing at the kitchen counter in her robe. The motion argued that the defendant's discovery requests and filings demonstrated a pattern of bad faith litigation designed to harass the plaintiff and avoid addressing the substantive fraud allegations. It argued that the defendant had no viable defense on the merits. It asked the court to dismiss the defendant's affirmative defenses, enter summary judgment on liability in favor of the plaintiff, and award enhanced attorney's fees as a sanction for the defendant's conduct. It was 22 pages, and it was aimed with surgical precision at the moment of maximum pressure, filed 3 days before the hearing when she would have almost no time to respond. She stood at the counter and read it twice. Then she went and woke up Miles. He came to the kitchen doorway in his pajamas, hair uncombed, blinking. She handed him her phone with the motion on the screen. He read it standing in the doorway, his eyes moving fast down the page, and she watched his face move through something she recognized. The initial registration of the blow, and then the recalibration, the shift into the mode that was not panic, but work. He handed the phone back. It's a pressure move, he said. I know. They filed it now because they're scared of the hearing. They want to either get the case ended before you can use the privilege log argument, or bury you in a response so you can't prepare for the hearing. I know. You can't respond to all 22 pages in 3 days. I don't need to respond to all 22 pages, she said. I need to respond to the core argument and file it before the hearing. The rest I can address at the hearing itself. She looked at him. Go get dressed. He went. She poured 2 glasses of orange juice. She had a rule about him and coffee, and she was keeping it even today. And by the time he came back to the table, she had the laptop open and the motion on the screen and a fresh legal pad in front of her. They worked for 4 hours straight. The response they drafted was 11 pages. It addressed the bad faith allegation directly and with documented specificity. Every filing she had made, every deadline she had met, every request she had made with its procedural basis cited. It pointed out that the emergency motion had been filed 3 days before a scheduled hearing on the defendant's motion to compel, and argued that the timing was itself evidence that the plaintiff sought to avoid judicial scrutiny of its discovery conduct rather than engage with it. It asked the court to deny the motion and note the timing for the record. The last section, Miles's contribution, which she had phrased and rephrased until it said what she meant in the language the court would receive, argued that filing an emergency motion for summary judgment 3 days before a discovery hearing in a case where the plaintiff had already been ordered to supplement deficient responses and produce a more detailed privilege log was not a good faith litigation posture. It was a strategy. She filed it at 11:47 that night. Miles went to bed at 10, which she had insisted on, and she had finished the final 2 pages alone at the kitchen table with the city quiet outside. When the filing confirmation came through on her email, she sat for a moment with her hands in her lap and thought about what her mother used to say about the people who mock you and what they are afraid of. She was starting to understand precisely what they were afraid of. The hearing was on a Wednesday. Courtroom 14C was more crowded than it had been at the status conference. There was a woman in the second row of the gallery whom Tiana didn't recognize. Professional clothes, a small recorder on the bench beside her, the alert stillness of someone who was there to listen, a legal observer or a journalist. There were 2 men near the back who had the look of corporate observers, people sent to watch and report. Miles sat in his usual seat right behind the partition, backpack on the floor between his feet, legal pad open. He had organized his materials the night before with his usual systematic precision, the timeline in the blue folder, the privilege log entries flagged in red, the case law citations he'd found in the practice guide paperclipped to the back page. Judge Whitmore entered. Everyone rose. We are here on the defendant's motion to compel, with a pending emergency motion to dismiss filed by the plaintiff. She looked at Carver. Mr. Carver, I've reviewed your emergency motion and the defendant's response. I want to address the timing before anything else. Her tone was not warm. You filed an emergency motion for summary judgment 3 days before a scheduled hearing on a motion to compel in which I have already found deficiencies in your client's discovery responses. Can you help me understand that decision? Carver stood. Your Honor, the plaintiff believes the defendant's conduct in this litigation. I'm not asking about the defendant's conduct. I'm asking about the timing of your motion. A pause. The plaintiff determined that the circumstances warranted immediate relief, Your Honor. The circumstances that warranted immediate relief were the same circumstances that have existed since this case was filed, Judge Whitmore said. The fraud allegations haven't changed. What changed is that there is a hearing today at which I will be examining your client's privilege claims in detail. She looked at him steadily. Your emergency motion is denied. We'll address the motion to compel. Ms. Brooks. Tiana stood. She had a single legal pad in front of her with 4 lines of notes, the 4 points she and Miles had agreed were the essential spine of the argument. Everything else she had internalized. She started with the privilege log entry from 31 months ago. She placed it on the visualizer connected to the courtroom monitor, a piece of equipment she had learned to request in advance through the clerk's office, which Miles had suggested 2 weeks ago after reading about courtroom technology in a procedural guide. The entry appeared on the screen. Your Honor, this entry in the plaintiff's privilege log is dated 31 months ago. According to public regulatory records, the state compliance investigation into Hargrove Meridian Solutions opened 5 months after this date. The defendant was promoted into the compliance liaison role 7 months after this date. She paused. The subject line reads Legacy Compliance Documentation, Strategic Considerations. The participants include General Counsel and 2 executives from Compliance and Operations. She advanced to the second entry. This entry is dated 23 months ago, 2 months after the investigation opened. The participants now include outside counsel. The subject line reads, Brooks Appointment, Compliance Transition Strategy. Another pause. The defendant's name appears in a privileged communication between the plaintiff's executive team and outside counsel, 2 months into an active state regulatory investigation in connection with the defendant's appointment to the exact role at the center of this lawsuit. The courtroom was quiet in the particular way courtrooms get quiet when something has landed. The plaintiff claims these communications are protected by attorney-client privilege and work product doctrine, Tiana continued. The defendant does not dispute that such protections exist. The defendant submits that where communications were made in connection with the placement of an individual into a compliance role during an active regulatory investigation, and that individual is now being sued for fraud related to that exact role. The question of whether those communications go to legitimate legal advice or to a strategy that affected the defendant's employment and legal exposure is not a question the court should accept the plaintiff's characterization on without review. She looked at Judge Whitmore directly. The defendant is not asking this court to invade privileged communications. The defendant is asking this court to conduct an in-camera review of those communications and make an independent determination of whether the privilege designations are valid. She sat down. In the gallery, the woman with the recorder leaned forward slightly. In the back row, one of the corporate observers typed something into his phone. Behind the partition, Miles wrote one word on his legal pad. Perfect. Carver stood. He was very controlled. Whatever he was feeling, and Tiana had become good enough at reading him to know he was feeling something, it was behind an expression of professional composure that had cost him decades to build. Your Honor, the defendant is essentially asking this court to second-guess a privilege designation on the basis of a subject line. These communications were made in the ordinary course of legal consultation during a period when the company was navigating a regulatory matter. The defendant's name appearing in a subject line does not make that communication discoverable. The defendant's name appearing in a subject line 2 months into an active regulatory investigation in connection with her appointment to the role she is now being sued over is not ordinary context, Judge Whitmore said. Your Honor, Mr. Carver. Judge Whitmore's voice was the kind of quiet that meant she had reached a conclusion. I'm going to conduct an in-camera review of the two communications identified by the defendant and any other communications in the privilege log that reference the defendant by name or role within the period of the regulatory investigation. She made a note. I want those communications in my chambers by end of day Friday. I will review them by next Wednesday and issue a ruling. She looked at Carver. If I find that the privilege designations are not supported, I will order production and we will have a conversation about the implications for this proceeding. She looked at Tiana. Ms. Brooks, anything further on the motion to compel? One issue, Your Honor. Tiana stood. She had been waiting for this moment, had saved it deliberately, on Miles's advice for after the privilege discussion when the court's attention would be fully focused. The plaintiff's complaint references $140,000 in damages. The complaint also incorporates, by reference, regulatory penalties from the state investigation. The defendant would ask the court to require the plaintiff to specify, in supplemental interrogatory responses, which damages are based on conduct allegedly occurring during the defendant's tenure and which are based on conduct from the pre-existing regulatory investigation. She paused. The defendant submits that the plaintiff may be seeking to hold the defendant liable for financial penalties that arose from conduct that predates her employment in the role by up to 2 years. The silence that followed lasted 4 seconds. She counted them. Judge Whitmore looked at the papers in front of her. She looked at Carver. She looked at Tiana. Mr. Carver, she said, can you represent to this court that the damages sought in your client's complaint are limited to conduct occurring during the defendant's tenure in the compliance liaison role? Carver's jaw moved slightly. Your Honor, the damages calculation is a complex matter that, can you represent it, yes or no? 3 seconds. Not without verification, Your Honor. The room moved. Not physically, nobody shifted or whispered, but something in it changed, the way air pressure changes before a storm. A subtle and unmistakable reconfiguration of what everyone in the room understood. Judge Whitmore wrote in the file for a long time. I am ordering the plaintiff to provide a detailed damages specification within 21 days identifying, for each element of damages claimed, the specific conduct underlying the claim and the dates of that conduct, she said. The defendant is correct that this court cannot assess the merits of the fraud allegations without understanding whether the alleged damages are attributable to the defendant's conduct or to pre-existing issues. She removed her glasses and let them hang on their chain. I will also note for the record that the defendant has, as a pro se litigant, raised procedural and evidentiary issues in this hearing that are sophisticated and well-grounded in the rules. This court does not determine outcomes, that is, for the finder of fact. But this court does ensure that both parties have access to the evidence and procedure they are entitled to. I intend to make sure of that. She put her glasses back on. We're adjourned. In-camera review materials to my chambers by Friday, 5 o'clock. The gavel came down. Did. In the hallway, Tiana sat down on one of the dark wood benches and let out a breath that felt like it had been compressed for 3 weeks. Miles sat beside her and said nothing for a moment, which was unusual enough that she looked at him. His eyes were slightly bright. Not crying. Miles didn't cry easily, hadn't since he was 8 or 9, a trait she had conflicting feelings about. But something close to it. The look of someone whose chest is full of something they are not sure where to put. You did that, he said. We did that. He shook his head slightly. You stood up there alone. Everything I said came from what you found, she said. The privilege log entries, the regulatory timeline, the damages specification argument, that was yours, Miles. You identified that 2 weeks ago. I found it, you argued it. She put her arm around his shoulders. He let her, which he didn't always anymore. 12 was complicated that way. She felt him lean slightly into her, just slightly, with the residual instinct of a younger child. She said sophisticated, he said quietly. The judge. She did. She was talking about your arguments. She was talking about our arguments, Tiana said. She held him there for a moment on the bench in the courthouse hallway that smelled like floor wax and old paper. Your dad would be... She stopped. I know, Miles said. They sat for another minute in the quiet. Then Tiana straightened. She picked up her portfolio. She looked at the hallway, long and marble-floored and institutional. and thought about the first time she had walked through it, shaking, in her navy blazer, certain she was walking into something designed to break her. "Come on," she said. "I want to get home before the news comes on. I need to start on the damages specification response before they even file it." Miles stood, shouldered his backpack. "I was thinking about that," he said, falling into step beside her. "Of course you were. The key is cross-referencing the regulatory consent agreement against the specific penalty amounts in the complaint. If the same dollar figures appear in both, then they copied the regulatory penalties into the fraud damages," Tiana said. "Right, and we can prove it. And we can—" They walked down the long hallway together, side by side, and behind them the courtroom door was closed, and the bench where Philip Carver had not been able to answer a direct question from a federal judge was empty, and somewhere in the building, Judge Whitmore was in her chambers making notes in a file, and somewhere in a downtown office, a corporate legal team was sitting around a conference table understanding fully and perhaps for the first time. "Dinner?" Miles said. "What?" "Spaghetti." "Dinner?" Miles said. "What?" "Spaghetti." She laughed, really laughed, the first full laugh in weeks, the kind that comes from somewhere below the chest and doesn't ask permission. "We're getting pizza," she said. The elevator doors closed. The pizza had been a good idea. They ate it at the kitchen table with the box open between them, Miles pulling strings of cheese off his second slice with the focused contentment of a boy who had spent 8 hours in a heightened state and was now, finally, allowed to simply exist. Tiana ate slowly and let the quiet of the apartment settle over her like something physical, a warmth, an absence of pressure. Outside the window, the city was doing its evening things. Inside, for the first time in a long time, the documents were closed and the legal pads were in the backpack, and there was nothing required of either of them except to eat and breathe. She watched Miles and thought about what the judge had said, sophisticated and well-grounded in the rules. Said about her arguments, in open court, in front of Philip Carver and his team and the woman with the recorder and the corporate observers in the back row. Said without sentimentality or condescension, just the plain assessment of a judge who had no reason to be anything other than honest. She had worked for that. Miles had worked for that. The months of kitchen table nights and library hours and practiced arguments and red-penned margins had built, incrementally and without fanfare, something that had stood up in a marble courtroom and been recognized for what it was. She didn't say any of this to Miles. Some things were better held quietly. "Judge Whitmore is going to read those communications," Miles said, on his third slice, still looking at the pizza box. "Yes." "What do you think she's going to find?" Tiana thought about the 2 privilege log entries, the dates, the subject lines, the weight of what they implied sitting against the documented timeline, like 2 pieces of the same puzzle that had been deliberately separated and placed in different rooms. "I think," she said carefully, "she's going to find something that makes the next conversation very different from every conversation that has come before." Miles chewed, nodded slowly. "And then what happens?" "Then we respond to whatever comes out of that review." She looked at him. "We don't get ahead of it. We see what the judge finds, and we respond to it, one step at a time." He looked at her with that evaluating gaze, checking, she had come to understand, not whether she was telling the truth, but whether she was all right, whether the woman across from him was managing, or whether she was drowning and calling it managing. "Okay," he said, apparently satisfied. "Finish your pizza." "I'm on my 3rd piece." "Finish it anyway." He almost smiled. He finished it. Bawan. Judge Whitmore's ruling on the in-camera review came on a Tuesday, 8 days after the hearing. It arrived through the court's electronic filing system at 2:14 in the afternoon, when Tiana was at work. She saw the notification on her phone during her lunch break, sitting in the hospital cafeteria with an untouched sandwich in front of her. She stared at the notification for a moment. Then she put the phone face down on the table, ate half the sandwich, and told herself she would read it at home, with Miles, the way they had read everything else in this case, together at the kitchen table with the legal pads and the color-coded folders and the discipline not to react before they understood. She made it until 4:30, which she considered a reasonable display of self-control. She was on the bus home, Miles's school bag visible through the window as she turned the corner of their block. He was sitting on the front steps, which meant he had beaten her home and was waiting. And she pulled out her phone and opened the ruling. It was 14 pages. She read the first 2 paragraphs standing on the sidewalk in front of their building, Miles watching from the steps with the backpack between his knees. "Mom," he said. "What does it say?" She looked up. "Get inside," she said. "I need to sit down." They sat at the kitchen table. She put the phone between them and they read it together, Tiana saying the words quietly while Miles followed on the screen, one hand flat on the table beside the phone, as if steadying something. Judge Whitmore had reviewed 14 communications in camera, the 2 identified by Tiana and 12 others she had identified independently from the privilege log as falling within the relevant period and involving the defendant's name or role. Of the 14, she had found 4 that she determined were not entitled to privilege protection under the crime fraud exception. The ruling did not reproduce the contents of those communications. What it did was describe them in enough detail to understand what they were. The first was dated 31 months ago. It was an email chain between Hargrove's general counsel and 2 executives. The ruling described it as containing discussion of the company's exposure under the pending compliance investigation, including explicit reference to the strategic value of transitioning compliance documentation responsibilities to a new individual who would have no prior knowledge of the legacy issues. Tiana read that sentence twice. "Strategic value," Miles said quietly, "of transitioning responsibilities to someone with no prior knowledge of the legacy issues." "They planned it," Tiana said. Her voice was very level. "They sat in that meeting and they talked about finding someone who didn't know about the problems, and they put her in the role so the problems would be hers." "Keep reading," Miles said. The second communication was dated 23 months ago, the one whose subject line read Brooks Appointment, Compliance Transition Strategy. The ruling described it as containing discussion of the defendant's appointment to the compliance liaison role in terms that reference the ongoing regulatory investigation and the anticipated resolution of the company's compliance exposure through the transition of record-keeping responsibility. The anticipated resolution of the company's compliance exposure. Through Tiana. The third communication was dated 18 months ago, 4 months into Tiana's time in the role. It was between the general counsel and outside counsel. The ruling described it as containing explicit discussion of the company's strategy in the event that a second regulatory inquiry arose, including reference to the defendant's role in the compliance documentation and the company's position that record-keeping errors occurring after the transition of responsibility would be attributable to the new compliance liaison. The fourth was dated 11 months ago, 3 months before Tiana was fired, and it contained, the ruling stated, discussion of initiating litigation against the defendant in the event that the anticipated second regulatory inquiry materialized, including reference to Exhibit 12 as documentation of the pre-existing compliance issues that would form the basis of the company's claims. They had been planning to sue her for a year before they fired her. They had planned the lawsuit, selected the evidence, identified their strategy, and then fired her and executed it. All of it was in writing. All of it had been sitting in the privilege log, designated as protected, on the assumption that no one would look closely enough or fight hard enough to get a judge to look at it. Judge Whitmore's ruling ordered immediate production of the 4 communications. It also stated, in language that was controlled but unmistakably pointed, the court finds that the privilege designations applied to these communications were made in bad faith, and that the communications themselves provide significant support for the defendant's theory that the plaintiff's lawsuit was brought not to remedy genuine fraud, but to implement a pre-planned litigation strategy designed to shift the plaintiff's own regulatory liability to the defendant. The court will convene an emergency hearing to address the implications of this finding for the proceeding. The last line read, "The court is also referring this matter to the clerk's office for consideration of whether sanctions proceedings under Rule 11 and the court's inherent authority are warranted." Miles sat back in his chair. He was very quiet for a long moment, the kind of quiet that meant he was at maximum processing capacity and needed the silence to work through it. "They're in trouble," he said finally. "Yes," Tiana said. "Serious trouble." "Yes." He looked at her. "Are you okay?" The question surprised her, not because it was unexpected from him. Miles asked it regularly, and meant it with the careful literalness of a person who had learned early that adults sometimes answered fine when they meant something else entirely. But because of the timing of it, here, now, in the moment when everything they had built together had just been confirmed as right. She thought about it honestly. She stopped, started again. I knew, she said. I think I knew from the moment they put me in that role. Not consciously, but somewhere I knew something was wrong. That I was being asked to be something other than what they told me I was being asked to be. She looked at the phone on the table, at the 14 pages of the ruling. And then Marcus died, and I was trying to keep everything together, and by the time they fired me and the lawsuit came, I was so scared and so tired that I couldn't hold the knowing and the fear at the same time. She paused. So I just held the fear. Miles was looking at her with the full stillness of his attention. But we found it, he said. We found it, she said. You found it. We, he said firmly. She reached across the table and put her hand on his. He didn't pull away. Yeah, she said. We. The emergency hearing was scheduled for that Friday. Carver filed a motion for a continuance Thursday morning, citing the complexity of the issues and the need for additional preparation time. Judge Whitmore denied it the same afternoon in a 3-line order that did not explain its reasoning, which in Tiana's experience of this judge meant the reasoning was so obvious she considered explanation unnecessary. Thursday night, she and Miles prepared. They had the 4 communications, produced that morning, 48 pages total, and the ruling, and the original complaint, and the timeline they had built over weeks, and the damages specification that Hargrove had filed 6 days earlier. Miles had spent 2 hours that afternoon at the library and come home with 4 printed pages of case law and sanctions under Rule 11 and the court's inherent authority, annotated in his careful hand. The damages specification, as Tiana had predicted, contained problems. She and Miles had found them within an hour of receiving it. 3 of the 8 damage categories in the complaint included figures that appeared, with slight modification, in the regulatory consent agreement, the same document, dating from the pre-existing investigation that Tiana had never been part of. The plaintiff had done the calculation Tiana had warned the court about and then done it anyway, apparently confident that it would hold. They're still trying, Miles said when they found the 3rd overlapping figure. They've come this far, Tiana said. They can't unfile the lawsuit. They can't admit what the communications show. So they push forward and hope something breaks their way. Nothing's going to break their way, Miles said. Not if we walk into that courtroom tomorrow with everything documented. They worked until 11. She sent him to bed. She stayed up until 12:30 going through the 4 communications one more time, cross-referencing each one against the timeline entries with a focus that had a different quality than anything she had brought to the case before. Because now she was not building an argument from inference. She was reading the record of what had actually been done to her, in the words of the people who had done it, and she was organizing it into a presentation that would place those words in front of a judge and let them speak. There was something cold and clarifying about that. She had expected anger, had been bracing for the kind of anger that makes you loud and imprecise, and instead what she found was a focused, almost crystalline calm, the kind that comes not from the absence of feeling, but from having found, at last, solid ground. She closed the laptop at 12:32. She sat for a moment in the kitchen quiet. Then she went to bed and slept without waking for the first time in months. Friday morning. Courtroom 14C. More people in the gallery than Tiana had ever seen in this room. The woman with the recorder was back, in the same seat, with a colleague beside her now. 3 men in the back row who she didn't recognize, not the same corporate observers as before, different ones, older, with the watchful quality of executives rather than staffers. On the plaintiff's side of the gallery, a woman in a burgundy suit whom Tiana recognized from a company press release she had found online, Hargrove Meridian's chief operating officer. The COO had come to watch. Tiana noted this, filed it, and looked at her papers. Miles, behind the partition, wrote in his legal pad, "They brought the COO. They're scared." He underlined it twice. Carver entered with his full team, all 4 attorneys, including Patricia Hollins from Appellate, plus 2 paralegals and a man Tiana didn't recognize who carried a separate briefcase and sat at the end of the table without being introduced. The full deployment, everything they had. Judge Whitmore entered. Everyone rose. "We are here on an emergency hearing convened by this court following the in-camera review of documents produced under the court's order," she said. She was wearing the same reading glasses, but her energy today was different. Not more formal exactly, but more deliberate. The way a person moves when they are carrying something that requires care. Before we begin, I want to state for the record that the findings in this court's ruling of Tuesday last were not the findings I anticipated when I ordered the in-camera review. I ordered that review because the defendant raised a legitimate procedural question about privilege designations. What I found in those communications goes considerably beyond a privilege dispute. She looked at both tables. "Ms. Brooks, you may proceed." Tiana stood. She put the first communication on the visualizer. The room could read the date, the participants, the subject line, and then, per Judge Whitmore's ruling ordering full production, the body of the email shares the actual words, written by Hargrove's general counsel 31 months ago, that she read aloud into the record. The email said, in the language of a legal professional discussing corporate risk with clinical detachment, "Given the exposure created by the documentation irregularities currently under regulatory review, the most defensible position going forward is to establish a clear transition of compliance record-keeping responsibility. The new liaison should have no prior involvement with the legacy documentation so that post-transition records can be cleanly distinguished from the issues under investigation. Recommend initiating the search for a suitable internal candidate." She read it once. She did not editorialize. She moved to the timeline entry for the same date, then the second communication, and the third, and the fourth. She read them in order, each one's place on the timeline, documented, each one's relationship to the next, the plan's evolution from concept to appointment to contingency strategy to pre-litigation preparation. The email chain in which outside counsel had been consulted on litigation strategy 14 months before Tiana was fired, 11 months before the second regulatory inquiry materialized, 15 months before the lawsuit was filed. The fourth communication was the one she read last and most slowly. It was a 2-page email chain between the general counsel and outside counsel, dated 11 months ago. It said, among other things, "If the second inquiry proceeds as we anticipate, the timeline of Brooks's tenure and the documentation record should provide a clean narrative attributing the outstanding compliance issues to her management period. Recommend retaining the Exhibit 12 materials from the prior investigation as foundation for any future claim." She set the page down. "Your Honor," she said, "the plaintiff's complaint accuses this defendant of fraud. It seeks $140,000 in damages. It characterizes her as someone who deliberately misrepresented compliance records and caused financial harm to the company." She paused. "What the plaintiff's own documents show is that the company identified her as a strategic asset for managing their regulatory exposure before she was promoted, that the company placed her in the compliance role specifically because of an active investigation she knew nothing about, that the company prepared a litigation strategy against her while she was still their employee, and that the damages they are seeking include regulatory penalties from an investigation that closed before she ever held the role." Another pause. This was not a fraud lawsuit. It was a contingency plan, and the defendant respectfully asked this court to treat it as such. She sat down. The room was completely silent, not the polite procedural silence of a courtroom waiting for the next speaker. Something else. The silence of people who have just heard something that requires adjustment, that asks them to rearrange what they thought they knew about what they were watching. Judge Whitmore looked at Carver. "Mr. Carver," she said, "the communications produced this week were withheld from the defendant under privilege designations that this court has found to be made in bad faith. Those communications describe a plan, developed while the defendant was your client's employee, to use her as a vehicle for your client's regulatory exposure and to pursue litigation against her in a specific anticipated scenario. That scenario materialized. This lawsuit followed." She took off her glasses and let them hang on their chain, which in Tiana's experience meant she was about to say something she wanted received without the filter of formality. "I have been on this bench for 19 years. I have presided over a significant number of civil matters. What I read in those communications this week was one of the more deliberate examples of litigation strategy designed to weaponize the judicial process against an individual that I have encountered. Carver was on his feet. Your Honor, with respect, you will have an opportunity to respond, Mr. Carver. Sit down. He sat. I am ordering an immediate freeze on all proceedings in the underlying case while this court considers appropriate sanctions under Rule 11 and the court's inherent authority. She picked up her pen. I am also ordering the plaintiff to show cause in writing, within 14 days, why this case should not be dismissed with prejudice as an abuse of process. She looked at Carver. Now, you may respond. Carver stood. He had composed himself. She would always give him that, the iron discipline of a man who did not let a courtroom see him break. His voice was even. His posture was contained. But Tiana had learned, over months of watching him, the tells that lived below the composure, the slight tightening around his eyes, the way his left hand, when he was not gesturing, closed at his side with just slightly more pressure than was comfortable. He was frightened. Your Honor, he said, the communications reviewed by this court represent internal legal strategy developed in the ordinary course of business. The plaintiff maintains that Ms. Brooks's conduct in the relevant period independently supports the fraud allegations, regardless of the context in which the litigation was prepared. He paused. The plaintiff is prepared to respond to the show cause order and to address the court's concerns regarding the privilege designations. We ask the court to reserve judgment on dismissal until the full record is before it. The full record, Judge Whitmore said, includes 4 communications that your client's counsel designated as privileged, and that describe, in your client's own words, a plan to make this defendant the instrument of the company's regulatory defense. That is now part of the record, Mr. Carver. You don't get to decide what I do with it. She put her glasses back on. The freeze is effective immediately. Show cause response in 14 days. I'm also directing the clerk to prepare referral materials for the State Bar's Ethics Office regarding the privilege designations. She closed the file with a precision that sounded final. We're adjourned. The gavel. The COO left the gallery fast, through the side door, with the burgundy suit and the controlled urgency of someone who needed to make a phone call immediately. The corporate observers followed. Patricia Hollins from Appellate leaned toward Carver and spoke in a rapid, low voice that Tiana could not hear. Thomas Osei, the youngest of the 4 attorneys, sat very still at the plaintiff's table for a moment, after everyone else had begun to move. He was looking at this table in front of him with an expression that was harder to read than the others. Not just the professional recalibration of someone managing a loss, but something more personal. The look of a young person encountering, perhaps for the first time at this scale, the distance between what they had been hired to do and what that thing actually was. He gathered his papers and left without speaking. In the gallery, the woman with the recorder was writing. Her colleague was already on a phone. Tiana sat at the defendant's table and let the room empty around her. She was not performing calm. She was genuinely, strangely, somewhere beyond the agitation of the past months, in a place that felt like the far side of something she had been climbing for a long time. She looked at the elevated bench where Judge Whitmore had sat. She looked at the visualizer where she had placed the communications and read them into the record. She thought about the certified mail that had arrived on a Thursday 8 months ago, the 47 pages, the $840. The woman who had sat at the kitchen table reading about herself in language that made her sound like a criminal, trying to understand how a thing could be written about her that was so thorough, so specific, so entirely wrong. Now she understood. Miles was beside her before she realized he had come around the partition. He sat in the chair next to hers, which he had not done before, had always maintained the separation between the gallery and the table, the rule they had implicitly agreed on from the beginning. He sat down and put his legal pad on the table and looked at the empty bench. "You okay?" he said. "Yeah," she said. "Are you?" He thought about it. "I think so," he said. "I think I'm—" He stopped, started again. "I knew it was real. I knew what we were finding meant something. But hearing you read those emails out loud—" He paused again. "It's different when it's out loud." "It is," she said. "They really planned all of it." "Yes." "While you were working for them, while you were doing the job they gave you specifically because—" He stopped himself. His jaw was tight in the way Marcus's had been when he was angry and choosing not to let it be loud. "Miles," she put her hand on his shoulder. "Let it be what it is." He exhaled. "It's a lot," he said. "It's a lot," she agreed. They sat there for a moment in the emptying courtroom. The mother and her son, the navy blazer and the button-down shirt, the portfolio and the backpack, the two people who had sat at a kitchen table for months and built, from library books and red pens and late nights, and the particular stubbornness of people who have nowhere to retreat to, something that had just made a room full of people in expensive suits go quiet. "What happens now?" Miles said. "Now we wait for the show cause response," Tiana said. "We see what Hargrove files in 14 days, and we prepare our own response to whatever they say." "Do you think they'll fight it?" She looked at the empty plaintiff's table, at the empty chairs where Carver and Lim and Webb and Osei and Hollins had sat, at the briefcase left behind in the rush of departure, forgotten. A paralegal came back for it 20 seconds later, scooping it up with the flushed efficiency of someone who had made a mistake they hoped no one would notice. "I think," she said slowly, "that there are people in a boardroom right now having a conversation about what this costs them and what it costs them to keep fighting." She paused. "And I think, for the first time in this entire case, that calculation does not favor them." Miles nodded. He closed his legal pad. He picked up his backpack. "Okay," he said. "Let's go home." They walked out of courtroom 14C together, past the dark wood benches where other people sat with their lawyers and their papers, through the lobby where the floor was marble and the light was institutional, and the building felt today no different than it had always felt. Only she was different. On the steps of the courthouse, in the gray afternoon light, Tiana stopped for a moment. She stood at the top of the steps and looked out at the street. The ordinary city, going about its ordinary business, cars and people, and the particular noise of a place that does not pause for individual reckonings, no matter how significant. She thought about Hargrove Meridian Solutions, about the boardroom where the conversation was happening right now, about the general counsel who had written the email about transitioning compliance responsibility to someone with no prior knowledge, about the outside counsel who had prepared a litigation contingency using her name as a variable, about the 4 attorneys who had sat across from her in this building and deployed every advantage they had and still ended up here. She thought about what they had assumed about her when she walked in alone. Then she walked down the steps into the city, Miles beside her, and the courthouse door closed behind them, and they went home. The show cause response arrived on day 13. It was 44 pages. Tiana received it at work, forwarded it to the apartment printer remotely, and came home to find Miles at the kitchen table with it already divided into sections, each one marked with a different color tab. "How long have you been home?" she said. "An hour," he said. "I got through the first 20 pages. She set her bag down and sat across from him. "What's it say?" He looked at her with an expression she had not seen on him before in this case, something between weariness and a kind of measured, quiet satisfaction. "They're not fighting it," he said. She went still. "They're not admitting everything," he added quickly. "They're lawyering it. But the argument they're making is essentially, the privilege designations were made in good faith even if the court sees them differently. The communications reflect ordinary legal strategy. The defendant's conduct still independently supports the fraud claims." He tapped the stack of papers. "They're not saying they should win. They're saying they shouldn't lose everything." He paused. "That's different." It was different. Tiana understood what that difference meant. Not victory, not yet, but a change in the terrain. A company that believed it had a winning case fought for the win. A company that was managing its exposure fought for the softest possible landing. "They're going to try to settle," she said. "I think so," Miles said, "before Judge Whitmore rules on the show cause. Before she rules, before the bar referral goes anywhere, before the press finds the communications." He looked at her. "If those emails become public, they destroy the company's credibility with every client and regulator they have," Tiana said. She sat back in her chair. She looked at the stack of papers, 44 pages of careful lawyering in the service of a company that had spent months deploying every weapon it had against a woman with no lawyer, and $840 in her checking account. She thought about what a settlement meant, what a dismissal meant, What walking away from this with her name cleared and her bills paid and Miles's future intact meant, not in the abstract, but in the specific material terms of a woman who had been holding the weight of this for the better part of a year. She thought about the 12-year-old boy across from her, with his red pen and his 4-colored folders and the legal pad that had started as a blank page and was now filled, both sides of every page, 2 pads, with the documented architecture of a defense that had done what no one in that marble courthouse had expected it to do. "Miles," she said. He looked up. "Whatever happens next." She stopped. Tried again. "I need you to know that what you did in this case, what you have done every night at this table for the last 4 months, is something I will never be able to fully—" "Mom," he said. "Let me finish." He was quiet. "You didn't just help me with a lawsuit," she said. "You looked at something that was designed to make me feel like I had no options, and you refused to accept that. You went to the library and you learned things that adults with law degrees get paid hundreds of dollars an hour to know, and you brought them home, and you sat down with me, and you made it possible for me to fight." Her voice was steady. She was keeping it steady, consciously, because the alternative was crying, and she had held this particular feeling for months, and she wanted to say it with her whole voice. "That's not a normal thing. You know that." Miles looked at the table for a moment. Then he looked up. "You did the fighting," he said. "I just made sure you could see." She looked at her son. Outside, the city made its sounds. The kitchen was warm and the light was low, and the 44-page show cause response sat on the table between them. And somewhere in a corporate building across town, a boardroom was in session, and a legal team was counting its losses, and a company was calculating the price of what it had done. And here, at a kitchen table in an apartment in East Crestwood, a mother and her son sat in the quiet of a thing they had done together and let it be, for just this moment, enough. The settlement offer came on a Wednesday morning, 11 days after the show cause response had landed on Tiana's kitchen table. It arrived not through the court's electronic filing system, but as a phone call. Carver himself, not an associate, calling her personal number at 8:47 a.m. while she was on the bus to work. She let it go to voicemail. She listened to the message during her lunch break, sitting in the same hospital cafeteria where she had first received Judge Whitmore's in-camera ruling, with the same untouched sandwich in front of her. Carver's voice on the voicemail was different from his courtroom voice. Still controlled, it would always be controlled. That was the architecture of the man. But with something underneath the control that she had not heard from him before. A careful quality. The voice of someone measuring each word against its weight. He said he was reaching out in the spirit of resolution. He said his client had authorized him to discuss terms. He said he believed there was a path forward that would serve both parties' interests and avoid further proceedings. He asked her to call him back at her earliest convenience. She listened to it twice. Then she put her phone in her pocket, ate half the sandwich, and spent the rest of her lunch break at the window looking out at the parking lot, thinking. She called Miles from the bus home. "Carver called," she said. A pause. She could hear him setting something down. Homework, probably, or the legal pad. "Settlement?" he said. "That's my read." Another pause. "What do you want to do?" It was such a Miles question. Not what should you do, not what does this mean. What do you want? He had always understood better than most adults she knew the difference between the tactical and the personal, and that both mattered, and that she was allowed to have an answer to both. "I want it to be over," she said honestly. "I want to clear my name. I want the money they owe me, and I want to never have to walk into courtroom 14C again." "Then call him back," Miles said. "But not today." "Why not today?" "Because calling him back the same day he leaves a voicemail tells him you're eager," Miles said with the pragmatic confidence she had come to rely on completely. "Call him tomorrow, after you've decided exactly what you need the settlement to include." She looked out the bus window at the city going by. "When did you get this smart?" she said. "I've been this smart," he said. It was the same thing he had said to her months ago, at the kitchen table, after the first night they worked together. But it landed differently now. Not as a deflection, but as a statement of fact, offered without apology. "Okay," she said. "Tomorrow. We'll talk tonight." Whoa. They talked that night for 2 hours. Miles had a list. Of course he had a list. Written on his legal pad in the careful 2-column format he had developed for organizing arguments. One side for what they needed, one side for the leverage that supported each demand. Tiana had her own notes, looser, more emotional, and they worked them together until both lists became one, and the one became something clear. What she needed, full dismissal with prejudice, so the company could never refile the same claims. A formal acknowledgement that the fraud allegations were without merit, not an admission of wrongdoing. She understood they would never agree to that, but language that made clear the claims were being withdrawn entirely and not merely settled. Monetary compensation sufficient to cover the legal costs she would have incurred if she had been able to afford a lawyer, plus the 8 months of wages she had lost in the gap between her Hargrove salary and what she was making now, plus the damages that Judge Whitmore's sanctions order would have imposed if the proceedings had continued. Miles had done the math on that last figure. The number on the legal pad was not small. "They'll push back on the acknowledgement language," he said. "Let them push. That's not negotiable." He nodded and put a star next to it. "They'll also try to include a confidentiality clause," he said. "So you can't talk about the case publicly." She looked at him. "What do you think about that?" He was quiet for a moment, which meant he was being genuinely careful rather than reaching for the first answer. "I think," he said, "that confidentiality protects them, not you. The whole reason they want to settle before Judge Whitmore rules is so that the ruling, and what it would say about what they did, never becomes public record." He paused. "If you agree to confidentiality, you get the money and the dismissal, but what they did disappears with it. And if I don't? Then they either refuse the settlement and go back in front of Judge Whitmore, which they cannot afford, or they accept terms without confidentiality and the record stays." He looked at her directly. "I think you should refuse the confidentiality clause. But it's your call. It's always been your call." She sat with that for a long moment. She thought about the woman with the recorder in the courtroom gallery. She thought about the corporate observers. She thought about the second regulatory inquiry that was somewhere out there, presumably still proceeding. The inquiry that had precipitated her firing, that had set this entire chain in motion. She thought about whether there were other women in other compliance roles at other companies, sitting at kitchen tables in the dark reading certified mail that had been designed to make them fold. "No confidentiality," she said. Miles made a note. "There's one more thing," he said. He looked at the legal pad. "Attorney's fees. Even though you didn't have an attorney." "I can't claim attorney's fees without an attorney." "You can claim costs," he said. "Filing fees, copying costs, research costs, everything you spent out of pocket to litigate this case. It's not the same as attorney's fees, but it's documented and it's legitimate." He slid the pad toward her. He had already started the list. "I kept every receipt, library copying fees, the notary costs for the filings, the bus fares to the courthouse, every single one." She looked at the list. She looked at her son. 37 cents a page. Bus fares. The small, accrued arithmetic of a defense built without resources, paid for in the margins of a budget that had no margins. "Miles," she said softly. "It's not much," he said, "but it's ours, and they should pay it." "They should pay it," she agreed. She called Carver back the next morning at 9 a.m. from the hospital administrator's office, which her supervisor had offered her after Tiana had explained quietly and without drama that she needed privacy for a legal call. Her supervisor, a woman named Diane, who had known about the lawsuit since Tiana started, who had never asked questions but had adjusted Tiana's schedule more than once to accommodate court dates, and who had said, on the one occasion Tiana thanked her for it, only, "You handle your business, we'll handle ours," had told her to take as long as she needed and close the door. Carver answered on the second ring. They talked for 22 minutes. She had her notes in front of her, but she didn't look at them often. She had internalized the list well enough, over the months of working with Miles on structure and preparation, that the frame of what she needed was simply present, available, organized in her mind the same way the tabbed folders in her portfolio were organized. She spoke with the measured precision of a woman who had stood in courtroom 14C and read corporate emails into the record in front of an audience that included a judge, a court reporter, and a room full of people who had expected her to be someone entirely different. When she got to the acknowledgement language, Carver paused. "That's a difficult ask," he said. "I'm not asking for an admission of wrongdoing," she said. "I'm asking for language that states the fraud allegations are withdrawn without merit. Your client gets to avoid a formal judicial finding of abuse of process. In exchange, the record reflects that these claims should not have been brought. Silence on the line. The confidentiality clause is also a problem, she said, before he could reframe. Ms. Brooks, the proceedings to date are public record, Mr. Carver. Judge Whitmore's in-camera ruling is public record. What I'm willing to agree to is not to proactively seek media coverage of the settlement terms specifically, but I will not agree to silence about the substance of the case. Another pause. Longer this time. I'll need to consult with my client, he said. Of course, she said. I'll need your response within 5 business days. After that, I go back to Judge Whitmore and let the show cause ruling run its course. She said it the way Miles had taught her, not as a threat, as a statement of procedure. The facts arranged in a sequence. What will happen if this doesn't happen? Clean, documentable, true. 5 days, Carver said. 5 days, she confirmed. She ended the call. She sat in the administrator's office for a moment with her hands flat on the desk, the grounding gesture, her habit now, and let out a long breath. Then she went back to work. Carver called back in 3 days. His client had accepted her terms, not all of them exactly as stated. There was negotiation on the monetary figure, which went 2 rounds before landing at a number that was, Miles calculated that evening with his phone calculator and the notes they had kept on every financial impact the case had created, within $4,000 of what they had set as the minimum. There was modified language on the acknowledgement, not withdrawn without merit, but dismissed with prejudice upon determination by the parties that the claims are not supported by the evidence developed during discovery. It was lawyers' language. It was careful, and it was hedged, and it was, Tiana and Miles agreed at the kitchen table that night, acceptable. Because what it said, in the language the court would understand and the record would preserve, was that Hargrove Meridian Solutions had looked at the evidence and decided not to pursue the fraud claims against Tiana Brooks. The case that had been built to destroy her had been looked at closely, and it had not held. There was no confidentiality clause. She signed the settlement agreement on a Tuesday at a conference table in a building downtown, alone. She had come alone deliberately, without Miles, because she had decided this particular moment was one she needed to inhabit by herself. She wore the navy blazer. She brought her portfolio even though she didn't need it, because she had carried it into every proceeding in this case, and she was carrying it out. Philip Carver was not present. Thomas Osei represented the company, which she had not expected. He sat across from her in a gray suit and was professional and quiet, and slid the documents across the table with a composure that she thought, watching him, cost him something. When everything was signed and the notary had done her work, she gathered her copies and stood up and looked across the table at Thomas Osei. He met her eyes. She thought about saying something. She had considered in the days before this meeting whether there was anything worth saying to a member of the team that had litigated against her for 8 months. Mostly, she had decided there wasn't. But looking at him now, young, careful, carrying something behind his composure that she recognized as the weight of having been on the wrong side of something and knowing it, she said one thing. You should be careful, she said, about what you put your name on. He looked at her for a moment. Yes, he said quietly. I know. She walked out. The check arrived 9 days later. Certified mail, which she appreciated without irony. She brought it home and set it on the kitchen table, and she and Miles looked at it for a long moment without speaking. It was a rectangle of paper with numbers on it, which was all it was, and also everything it was. 8 months of fighting, of double shifts and library hours and late nights, and a kitchen table covered in color-coded folders, compressed into a series of digits on a check made out to Tiana Brooks. Okay, Miles said finally. Yeah, she said. What do we do first? She had thought about this. She had made a list because she was a person who made lists now. She had become one, gradually, through the months of working with a boy who organized everything and had taught her, without ever explicitly teaching her, that the act of writing something down was the first step in making it real. Rent. 3 months she was behind, which the landlord, Mrs. Petrovich, 67 years old, who had lived in the building for 40 years, and who had said to Tiana last month, in the hallway, with the careful directness of someone who could not afford sentimentality but possessed it anyway, had deferred without asking for a detailed explanation. First thing. Then the utilities, the credit card that had absorbed the cost of the months when the hospital salary hadn't covered everything. Then the student loan that had been in deferment for 2 years. Then in the savings account she was going to open at the credit union on the corner, an amount she had calculated based on Miles's school costs for the next 2 years, field trips and lab fees and the school laptop that was 4 years old and ran slower every month. And then at the bottom of the list, one item that was not practical and was entirely necessary, a weekend somewhere, just the two of them. Anywhere that was not the apartment and not the courthouse and not the hospital and not the bus between them. Somewhere that smelled like nothing in particular and where nobody knew their names. Rent first, she said. Rent first, Miles agreed. Then the rest. In order? In order. He nodded, satisfied with this, and she deposited the check at the bank on her way to work the next morning and stood at the ATM afterward, looking at the account balance, and felt something happen in her chest. A releasing, a decompression, the physical sensation of a weight she had been carrying so long she had stopped noticing its full measure coming off her shoulders all at once. She stood on the sidewalk outside the bank in the morning light and just breathed for a moment. Then she went to work. 2 weeks after the settlement, she received an email from a woman named Constance Adler, who identified herself as the director of a nonprofit legal advocacy organization called the Workers' Rights Litigation Clinic, operating out of a suite of offices at the county courthouse. She had heard about the case, through what channels exactly she did not specify, but the woman with the recorder had published 2 pieces about the proceedings, and the public record of Judge Whitmore's in-camera ruling had been referenced in both, and the legal world of the city was not, it turned out, as large as it appeared from the outside. Constance Adler wrote that she had followed the proceedings with considerable interest. She wrote that the litigation clinic provided pro-SC support and representation to workers facing employment-related lawsuits, and that Tiana's case had demonstrated the kind of preparation and procedural competence that the clinic tried to cultivate in its clients. She wrote that she would like to meet with Tiana to discuss whether there were ways the two of them might work together. The postscript was brief. It said, "I also understand you had some rather extraordinary assistance in building your case. The clinic would be interested in speaking with you about that as well, when appropriate." Tiana read the email twice. She forwarded it to the printer. She put it on the kitchen table when she got home and set a glass of orange juice on top of it and waited for Miles to read it. He read it standing up, which he did when something engaged him before he had time to sit. When he finished, he looked at her. "She knows," he said. "She figured out some of it," Tiana said, "probably from the filings, the way the arguments were structured." "Is that—" He stopped, started again. "Is that a problem?" "Why would it be a problem?" He set the email down. He was thinking through something. "Because it's my work," he said, and the way he said it was careful, almost tentative, as if he were testing how the words felt. "I don't know if I want people to... I don't know what happens when people know." She looked at her son. She had anticipated this, in the way she had learned to anticipate the things that would matter to him before he said them, not because she could read his mind, but because she had paid attention to him all his life, and she knew the things he valued and the things he guarded. What Miles valued, accuracy, fairness, the satisfaction of a problem correctly solved. What he guarded, the right to be 12, the right to still be the person in the bedroom with the homework and the video game on Saturday afternoon, and the library books that were just library books and not evidence of something extraordinary being deployed in a legal proceeding. "Nothing has to happen," she said. "We meet with her. We see what she says. You don't have to be part of anything you don't want to be part of." She paused. "But Miles, if what we learned in this case could help someone else—" "I know," he said. It was quiet and not resistant, just the sound of a person processing something true. "Not your work specifically," she said. "The resources, the research you compiled, the procedural guides, the timeline format, the discovery approach. None of that requires you to be the one who shows up." She looked at him. "You can be the person who built the tools and let the tools go. They don't have to carry your name." He was quiet for a long time. Outside, someone in the building was cooking something that smelled like onions and warm bread, and the ordinary evening life of a place where people came home and fed themselves and kept going. "Can I think about it?" he said. "Of course," she said. "For how long?" "As long as you need." He picked up the orange juice. He drank some of it. He set it down. "I want to meet her," he said, "just to hear what she's thinking, not to commit to anything." "That's exactly right," Tiana said. "That's what we'll do." They met Constance Adler on a Saturday morning at the litigation clinic's offices, which were in a suite on the third floor of the courthouse annex and were determinedly, cheerfully uncourthouse-like. Bright walls, plants on the windowsills, a shelf of children's books in the waiting area that Tiana suspected was there for exactly this kind of circumstance. Constance Adler was 60. Black, with natural gray hair and reading glasses that she wore on her face rather than on a chain, and the energy of someone who had chosen this work not as a compromise, but as the thing she most wanted to do with her time on Earth, and had been doing it for 30 years, and had not yet run out of reasons. She shook Tiana's hand and then Miles's hand with the same gravity, which Miles registered and appreciated. She could see it in the small adjustment of his posture, the microscopic relaxing of a kid who had been prepared to be treated like a curiosity and was being treated instead as a person. They sat around a table in the conference room, Constance with a notepad, Tiana with her portfolio out of habit, Miles with his backpack and his legal pad, because there was apparently no situation in the universe that would induce Miles to attend a meeting without his legal pad. Constance talked about the clinic, its work, its clients, the gap between the legal resources available to corporations and the legal resources available to individual workers that she had spent 3 decades trying to narrow. She talked about what she had observed in the public record of Tiana's case, the procedural competence, the argument structure, the discovery strategy, the willingness to push on privilege designations that most pro se defendants would have accepted without question. "I want to be direct," she said, and looked at Miles. "The filings in this case bear the marks of research and organization that I have seen from very few represented litigants, let alone pro se defendants. You're 12 years old, and you built what amounts to a discovery strategy that forced a well-funded legal team to produce documents they had designated as privileged." She paused. "I'm not going to make a production of that, but I want to acknowledge it, because I believe in calling things what they are." Miles looked at the table for a moment. Then he looked up. "My mom did the arguing," he said. "Your mom argued brilliantly," Constance said, "and I suspect she'd tell me she wouldn't have had anything to argue if you hadn't found it first." "We work together," Tiana said. Constance nodded slowly. "What the clinic needs," she said, "is not Miles's labor. I want to be very clear about that. He is 12 years old, and his job is to be 12 years old, and that is a full-time job and a valuable one, and I have no interest in disrupting it." She looked at both of them. "What I'm interested in is whether the framework you developed, the research approach, the document organization methodology, the discovery strategy, could be translated into a resource that other workers in similar situations could use. A guide, a set of tools, something that could be in the clinic's library and on the clinic's website and in the hands of the next person who receives a lawsuit at their kitchen table and has no idea what to do with it." Tiana looked at Miles. He was looking at Constance with the evaluating gaze she knew well, the gaze that was measuring something, checking something, deciding whether the thing in front of him was what it appeared to be. "The next person," he said. "The next person," Constance confirmed, "who might not have a kid who spent 3 weeks at the library. Who almost certainly won't," Constance said honestly, "which is why the tools need to exist independently." Miles was quiet. Then he opened his legal pad to a blank page. He uncapped his pen. "I'd want to be involved in writing it," he said, "not just handing over my notes. I'd want to make sure it's explained the right way." "I would insist on it," Constance said. "And I'd need it to not be about me," he said. I don't want to be a story. I want the guide to be a guide." "That's exactly what I want," Constance said. "The guide is the thing that matters, not who built it." Miles looked at Tiana. She gave him nothing, deliberately, because this was his decision, and she had known since the moment she read Constance's email that whatever Miles decided, she would support it, and she did not want her own expression to be the thing that tipped him either way. He looked back at Constance. "Okay," he said. He wrote the date at the top of the page and underlined it. "Tell me what you're thinking," he said. "From the beginning." They worked with the clinic over the following 2 months. Saturday mornings, mostly, with occasional weekday evenings when Constance had a client situation that offered a useful case study. Miles organized his notes into sections, and then into chapters, and then into a document that Tiana formatted on the laptop, and Constance's staff edited for accessibility. The guide covered discovery requests, privilege log analysis, timeline construction, damages specification, the mechanics of a motion to compel. It covered, in plain language that had been tested on 3 clinic volunteers who had no legal background, the procedural rights that a pro-SE defendant had that many such defendants didn't know to exercise. Miles had a rule. Every section had to be explainable to someone who had never been in a courtroom. He tested this by explaining each section to Tiana's mother, who had come to stay with them for a week in November, and who sat at the kitchen table on 2 evenings and listened to her grandson walk her through privilege logs and discovery deficiency letters with the focused patience of a woman who had worked a hospital laundry for 31 years and was not about to be outdone in the patient's department by anyone. After the second evening, Tiana's mother had looked at Miles for a long moment in the kitchen, quiet, and then turned to Tiana and said, "He gets this from you, you know, that thing where he just refuses. He gets that straight from you." Tiana had not said anything, but she had thought about it afterward, in the specific way she thought about things that mattered, turning them over, looking at them from different angles, feeling for what was true. She thought her mother might be right. The guide went live on the clinic's website on a Tuesday in December. Constance sent an email to the clinic's network, client contacts, partner organizations, legal aid offices across the state. The document was 43 pages, downloadable as a PDF, and listed its authors as the Workers' Rights Litigation Clinic, with research contributions from the Brooks legal team. Miles had approved that phrasing specifically. He had read every option Constance offered and chosen the one that credited the work without centering the person. That same week, Tiana received an email from a woman named Renata Okonkwo, who had found the clinic's guide through a legal aid network in a neighboring county. Renata had received a lawsuit from her former employer, a mid-sized manufacturing company, alleging breach of a non-compete agreement, and had been told by 2 attorneys that she would need a retainer she couldn't afford. She had read the guide twice. She had questions. Tiana forwarded the email to Constance, who connected Renata with the clinic's direct services. But she also wrote back herself, a short email. Not legal advice, she was careful about that, and Constance had been very clear with her about the lines. But a note that said, "You are not without options, and the people at the clinic know what they are doing, and I want you to know that someone read your email and it mattered." She showed the email to Miles that evening at dinner. He read it. He handed the phone back. "Good," he said, and ate his food. She looked at him across the table. Her son, in his regular clothes now, no button-down, no backpack, just a kid at dinner, and thought about the courthouse on the 14th floor and the marble floors and the day she had walked in alone and the room had been so certain about what she was and what she was capable of. She thought about everything they had been wrong about. On a Saturday in January, 6 weeks after the settlement and 2 weeks after the guide went live, Tiana drove them to the coast. She had rented a car for the weekend, a practical small sedan, nothing extravagant, and they had packed overnight bags and left at 7 in the morning while the city was still mostly asleep. Miles slept for the first hour of the drive, which she had expected, and she drove through the thinning suburbs and the long stretch of highway with the radio low and the early light coming in gray and clean through the windshield, and she thought about nothing in particular, which was itself a thing she had not done in months, and which felt like the particular luxury it was. He woke up somewhere past the halfway point when the road had started to bend toward the coast, and the air coming through the vents had changed character. Saltier, cooler, carrying the particular message of the ocean. "Where are we?" he said, with the disoriented clarity of a person coming up from deep sleep. "Almost there," she said. He looked out the window at the flat coastal plain going by, salt grass and scrub pine, and the occasional marsh reflecting the pale January sky. "I've never been to the ocean," he said. "I know," You have? Once. When I was little, my mom took me. She paused. I've been thinking about it a lot lately. He was quiet, looking out the window. What was it like? He said. Big, she said. It was just big. Bigger than anything I'd had to think about before. She glanced at him. I remember feeling like whatever was bothering me at the time, whatever 8-year-old problem I was carrying around, just got very small. Like the ocean made everything rescale. Miles considered this. I could use some rescaling, he said. She laughed. He almost smiled. They drove. Good. The beach was nearly empty on a January morning. A few distant figures walking dogs, a man with a metal detector working the high tide line, the gulls doing their perpetual business in the gray sky above the surf. The water was cold and tremendous, and green-gray and loud in the way the ocean is always loud, the sound filling the entire available atmosphere and leaving no room for smaller sounds. Miles stood at the water's edge for a long time without speaking, his sneakers getting wet because he'd stood too close and the wave had come farther than he'd anticipated, and he hadn't moved back. Tiana stood beside him. The wind was cold and direct, and the kind of clean that only exists at the edge of things. The edge of the land, the edge of the year, the edge of something that had taken months to get through and was, now, on the other side. Can I say something? Miles said. Yeah. I was scared, he said. This whole time. I don't know if you knew that. She looked at him. I knew. I didn't want you to know, he said. I thought if you knew I was scared, you'd try to protect me from it, and then I wouldn't be able to help. She was quiet for a moment, listening to the ocean filling all the space. I was scared too, she said. Every day. I know, he said. But you kept going anyway. So did you. He looked out at the water. Another wave came, and his sneakers got wet again, and he still didn't move back. Dad would have loved this, he said. He would have, she said. He'd have been in the water by now, in January. He'd have been absolutely in the water. Miles made a sound. Not quite a laugh, but in the same family as one, the sound of grief that has been carried long enough that it can coexist with warmth. He would have been terrible in court, Miles said. He absolutely would have, Tiana said, and she laughed, fully, the same way she had laughed in the courthouse elevator months ago, the kind that comes from somewhere below the chest and doesn't ask permission. He'd have argued with Judge Whitmore about something. He'd have decided Carver needed to be confronted directly. He'd have made everything worse. And then he'd have apologized and somehow made it better, Miles said. Yes, she said, exactly. They stood there for a little while longer in the cold and the sound of the water, together, carrying the thing they always carried, and finding that it was a little lighter than it had been. Then Miles turned and started walking up the beach, hands in his jacket pockets, heading toward the stretch of empty sand that ran north along the shore as far as either of them could see. Come on, he said. She followed. They walked for an hour along the water's edge, sometimes talking and sometimes not. And the city and the courthouse and the 4 attorneys and the certified mail and the 47 pages and the privilege log and the kitchen table and the months of it, all of it was still real, still part of them, always would be. It didn't disappear. That was not the kind of story they were living, the kind where things disappeared. But it was smaller, at the edge of the ocean in January, with the salt air filling everything and the gulls doing their business overhead. It had its right size. Miles picked up a stone from the wet sand, flat, gray, the kind that skips, and threw it at the water. It hit a wave and sank immediately. That was bad, Tiana said. I know, he said. He picked up another one. You need a flatter angle, she said. I know how to skip a stone. Clearly. He threw the second one. It skipped twice before a wave ate it. There, he said, with a satisfaction entirely disproportionate to 2 skips. 2, she said. Incredible. He looked at her with the expression he got when she was teasing him, and he was deciding whether to respond to it or preserve his dignity. He picked up a 3rd stone and handed it to her. She looked at it, flat, palm-sized, smooth. She turned it in her hand the way she had turned everything this year, looking at it from all the angles before she committed. Then she threw it at the water, low and hard, and it skipped 5 times before a wave took it under. Miles stared at the water. 5, he said. 5, she confirmed. He looked at her. She looked back at him. Her son, 12 years old, sneakers wet, hair blown sideways by the coast wind, standing at the edge of the Atlantic on a January morning with the whole long run of beach ahead of them, and nothing required of either of them except to be here and keep walking. Okay, he said. That was good. She reached over and put her arm around his shoulders, and this time he didn't lean in slightly. He just stood, solid and warm beside her, the way someone stands when they are exactly where they are supposed to be. Yeah, she said, it was. They walked north along the water, and the waves came in, and the gulls turned overhead in the gray sky, and the city was 2 hours behind them, and ahead was just the long, clean line of the shore going on and on into the pale distance, which was, for now, enough, which was, for now, everything.